You're welcome.
Okay, it looks like we're up and live streaming. So good morning, everybody. Welcome to the Joint Standing Committee on Veterans and Legal Affairs. We're gathered today for work sessions. We will start with introductions, and I will start with Senator Hickman, please.
Thank you, Mr. Chair. Good morning, everyone. Happy Friday. I'm Craig Hickman. I represent Senate District 14, 11 towns in southern Kennebec County, including my hometown of Winthrop.
Senator Farron.
Good morning, everybody. My name is Brad Farron. I live in Norwich Walk, and I have the distinct honor and privilege of representing the majority of the folks in Somerset County and the town of Rome in Kennebec County.
Representative McCrate.
Good morning, everybody. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Representative Riley.
Hi, Representative Riley. I represent House District 34, which is part of Westbrook.
Representative Supika.
Good morning. I'm Laura Supika, and I represent District 126, which is a portion of Bangor.
Representative Dolph.
Oh, good morning. Representative Josiane Dolph from District 115, which is in the Western Mountains, including the beautiful towns of Roxbury, Rumford, Milton Township, Woodstock, and Sumner. Thank you. Beautiful out there.
Excellent. Representative Kinney.
Good morning. I'm Representative Kinney. I represent House District 99, the towns of Brooks, Burnham, Freedom, Jackson, Knox, which is my hometown, Monroe, Thorndike, Troy, and Unity. And I'm in the State House today, even though you still get to see my puppy dog. And I'm enjoying the breeze. We've got a nice breeze in the committee room because we got the windows open. It's gorgeous outside.
Nice. Representative Wood.
Good morning, I'm Barb Wood. I represent House District 38, which is the western end of the peninsula in Portland. And I have to say that I have opened my windows for the first time today. It's lovely, but if the neighborhood spring construction becomes annoying, I will close the windows.
Much appreciated, Representative Wood, for sure. And last but not least, Representative Corey.
Good morning, I'm Patrick Corey. Allergies. I represent House District 25, which is part of Wyndham. Thanks.
Thank you. And I am Chris Chiazzo. I represent House District 28, beautiful Scarborough. My windows are not open. I'm jealous. I may sneak out a little bit and try and open them up. But we are also joined by our dream team, our analysts, Janet Stokoe, and our amazing clerk, Karen Montel. So I'll start with some instructions on the work sessions. The purpose of this meeting is for the committee to receive information from staff and others in order for members to consider the legislative proposals before them and make recommendations or reports to the legislature. Only committee members, the committee analysts, and those specifically invited to attend will be participating in the work session using Zoom. For members of the public wishing to observe this meeting, it is being live streamed on the committee's YouTube channel and will also be recorded for reviewing after the meeting is concluded. We are also broadcasting the audio for this meeting via the legislative website. The YouTube live stream of this meeting, which is accessible to the public, begins at the scheduled start time, which it has, and will remain on until the end of the work session. If your video or audio is on, even if the committee is not in an active session or is on break, the public can see or hear you. This is a public meeting, and while we are meeting, discussions must happen on screen and not by the way of the Zoom chat. You may use the chat to request to speak or to indicate that you have a technical issue or to indicate that you are momentarily stepping away from the screen. However, again, you are not to use the chat feature for substantive discussions. If you are having any technical difficulties, please contact the committee clerk, who will try to resolve the problem, or contact the Legislative Information Technology Office. The rest is protocol. I think we're very comfortable with that. And having said the introductions, I think we will start, if we could, by opening up the work sessions with LD 818, if we could, please, Janet.
Certainly. So LD 818 is an act to limit spam texting. It's a concept draft from Senator Rafferty. It proposes to establish a process for a person to opt out of receiving text messages from political, referendum, and advocacy campaigns, as well as the creation of a do not text registry for a person who does not wish to receive political text messages. At the public hearing, the sponsor made the following suggestions for amending the concept draft: to require explicit, transparent consent of cell phone owner to receive text messages. After the consent is provided, the cell phone owner would be given information outlining the types of text messages the cell phone owner agreed to receive, authorizing the cell phone owner's previously given consent to later revoke the consent, and then allow that owner access to the owner's personal data held by the entity that's sending the text messages, and require it to explain how it's using that data, and then report any breaches in that data within 72 hours. Additionally, for some information, I reached out to the analysts who work for the EUT committee because I don't have any experience in the regulation of utilities, including telephones and things like that. And they did point me in the direction of the Federal Telephone Consumer Protection Act. So that law, which was originally enacted in 1991, generally prohibits a person from engaging in the following activities. And that would include using an automatic telephone dialing system, which would be like a robocall or a robotext system, to make a call or send a text message to any cellular telephone number without the express prior consent of the recipient. Also prohibits making a call to a, this actually is supposed to say household number. I edited this so many times I didn't catch that. That uses an artificial or pre-recorded voice without the express prior consent of the recipient. Oh no, that was right. Sorry, I'm really tired. That is a cellular telephone number. So if you either use a robo dialing system or you use an artificial or pre-recorded voice and you make that call or text to a cell phone, then you need express prior consent. As far as household calls, the federal law restricts pre-recorded or artificial voice calls, telemarketing calls, and solicitations to residential telephone numbers. In addition, this is the federal law that provided authorization for the creation of the National Do Not Call Registry. This federal law's prohibitions apply not only to businesses, but also to campaign-related robocalls and robotexts. And the Federal Communications Commission has information right on its website about political campaigns and how they're affected by this law. And it explains that political text messages can be sent without the intended recipient's prior consent if the message sender does not use auto dialing technology to send the text and instead manually dials them. So generally speaking, if you're a campaign or somebody interested in the campaign or interested in politics, or even a business, but for the purposes of this bill, interested in politics, and you have a whole list of numbers that you want to send text messages to, if you manually type them in and send the text message, it's not covered by the federal law. But if instead you use some kind of technology to automatically generate the text messages to each of the numbers on your list, then you do have to have the prior consent of the recipients. The way that the concept draft is written or suggests that something should be written is targeting political messages, and that raises some potential constitutional concerns. So under US Supreme Court precedent, although the government may impose reasonable time, place, and manner regulations on speech, the First Amendment prevents it from discriminating in the regulation of expression on the basis of the content of that expression. So if a law or regulation singles out a specific subject matter for differential treatment, it is considered a content-based regulation on speech and is subject to strict scrutiny. So in a case that arose in 2020, the US Supreme Court examined a 2015 amendment to the federal law we were just talking about telephone calls, that exempted any call that was made solely to collect a debt owed to or guaranteed by the United States from the robocall prohibitions. So several political consulting organizations who wish to make robocalls to discuss candidates and issues, to solicit donations, to conduct polls, and to engage in similar political activities challenged the federal law's new federal debt collection exception on First Amendment grounds. The US Supreme Court, when it looked at the fact that the federal law required you to have express consent to send a text message or to make a telephone call to a cell phone if you were a political organization, but it wouldn't have required that express consent if you were the federal government or a debt collecting agency trying to collect a debt on behalf of the federal government. So they looked at that distinction, and they agreed that the exception violated the First Amendment, because while the government's collection of debts is certainly an important government interest, the government had not sufficiently justified the differentiation between government debt collection speech and other important categories of robocall speech, such as political speech, charitable fundraising, issue advocacy, commercial advertising, and the like. So that's a quote right from the case. So my message to you is that if the legislature enacts a spam texting registry or some kind of restrictions focused specifically on prohibiting unsolicited political text messages, but nevertheless authorizing other types of unsolicited text messages, the state will face the potentially steep challenge of articulating a compelling government interest in prohibiting political, but not other types of spam texts. And I'm using spam there to mean unsolicited or unwelcome. And just to remind you, don't know why that link appears there again, but the free speech clause of the First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office. So to the extent you're restricting political speech, you need to be very cautious and make sure you articulate a good reason and really draft it in such a way that you could try and withstand a First Amendment challenge. So if you did want to move forward with this, because it was a concept draft, I did raise several questions to you about who would administer the registry or who would oversee the regulations. I didn't know if you would think of the Ethics Commission or the Public Utilities Commission. In addition, what categories of text messages would be affected? Only political ones as suggested in the concept draft, only unsolicited messages. How can you make sure you carve out, if you want to, text messages sent by individuals for personal reasons? And then also, if the intent is to impose limitations on text messages sent by one person in Maine to another person in Maine, or by and to a Maine resident, because remember, Maine has jurisdiction over Maine, and interstate commerce, including calls and texts, are really controlled by the federal government. So if you wanted to restrict it to Maine, how is the person who's sending the message going to know that the recipient is either located in Maine or a Maine resident, depending on your approach, when the message is sent? So for the federal law, you can tell that a phone number is a US phone number, but you can't tell that a Maine cell phone number is a Maine cell phone number, because we don't all use 207 anymore. And even if you have 207 and you move, you can keep that area code. Sorry, couldn't think of the phrase. You can keep that when you move. So I just wondered how the person would know. There may be an easy way to know. I don't know anything about regulating cell phone usage, so it's possible that's not really an issue, but I just raised it. I don't know if you're aware, but I still get all the testimony in my email inbox. And I did notice that the sponsor had submitted testimony, well, what looks like testimony through the portal, but it does look to be a proposed amendment. So I didn't know if you all were aware of that, or whether I should present that or not, or what you want to do about that. But that would be this submission here from today, this morning.
Yeah, I didn't see that come in. It doesn't go to my email directly anymore. So if you want to kind of briefly walk us, if you prepared it, Janet, you want to walk us through it, that'd probably be good.
So I looked at it quickly, and I've been speaking to Jonathan Wayne about it this morning, the Executive Director of the Ethics Commission. I don't know that I know all the implications, but I will show you what I did receive in my inbox. So this looks like it's an amendment to 1014, which is a section of Title 21A, which talks about different communications. This is the section that requires disclosure of whether a communication is authorized by a candidate or not authorized by a candidate. It also has in here the requirements for the top 3 funders of an independent expenditure that involves a communication to be disclosed. That's not what this is about, but this is that section of statute. And down here, there's a highlight, but I would point out that none of 5A, which is on this page, actually exists in current law. So all of this would be new. So it would state that text message communications that name a clearly identified candidate during the same time period before the election that is used to define independent expenditures. So if it's made a text message, it names a candidate, and it's in a short time frame before the election, it must clearly state the name of the person who made or financed the expenditure for the communication, and whether the communication was authorized by a candidate or the candidate's authorized committee, and it also must include an opt-out option. As I look at this, these are just my initial thoughts because I just read it this morning. First of all, to point out, as I mentioned, that although only this part is highlighted, this whole subsection would be new. I did wonder, probably mostly because my husband still has a flip phone, so I really know how limited the number of characters are in text messages because my messages to him get mixed up all the time. So if you have to include the disclosure of whether it's authorized by the candidate or not, that's going to be a certain number of characters. And then you're going to also have to include the opt-out option. So I just wondered if you had any concerns. I don't care either way, but I just wanted to point that out. That's a lot of new characters to put in one text message, which is maybe fine, like I pointed out. For that reason, I wondered, there are other provisions like the top 3 funder provision that are in this section 1014 that do have specific rulemaking authority for the Ethics Commission to kind of define it. I didn't know if that would be helpful in saying how you do this, if that could make it shorter or not. I don't know if they think they could do that or not, because they didn't know about this until I emailed them and asked them if they saw it this morning. And then also I wanted to point out that the only limitation here is that there's an expenditure that was made for the communication. So we have to look at the definition of expenditure to see what kind of communications are we talking about here. I don't know if you can see that very well. I'm going to try and zoom in on it a little.
Yep,
So expenditure, you can, okay. So
Yep.
expenditure is defined broadly and includes any kind of gift of money or anything of value. So I'd imagine it's valuable for me to be typing in something onto my phone and sending it on your behalf if you're running for office. But I don't know the exact contours of where that cuts off as value. There are some exceptions to the definition of expenditure, however. The one that jumped out at me is number 10. So if a state party commission is paying its own employees, they can provide at least 40 hours assistance to any candidate in any election. That wouldn't be considered an expenditure. So if text messages are being sent by party employees and those employees spend less than 40 hours for any one candidate sending out these text messages, they would not be covered by this provision. So that just jumped out at me. I also wanted to point out that there are some exclusions to the types of expenditures. This is 1014 of current law. Sorry, I switched it on you without warning you. So in 1014, for all the other provisions that talk about communications that have disclosures on them about whether it was financed by the candidate, there are all the exceptions, which we talked about, like hand-painted signs. We've talked about that in here before. There is an exception for internet and email activities costing less than $100. And that does not, the way it's written, cover a text message. But I was just trying to think of an individual, like if I myself, which it wouldn't be me because then I'd lose my job. So let's say random other person off the street in Maine really, really wants to influence an election, and they have all their friends. I mean, I get emails from some people like this, and I'm like, why did I get on your list? I don't even know how that happened. But let's say they start texting all their friends and say, go out and vote specifically for, and they insert the candidate's name. I don't know how many messages they have to send for that to be considered an expenditure, but there's not going to be this exception for less than $100, and they might not really be doing anything than other than emailing, texting their friends. That may be fine with you because maybe that's what you want to include. But I just wanted to point out sort of my initial brush of what does this include if you were to adopt this. And then of course the opt-out option, we can work on how to write that, but that's easy enough. That's just a drafting issue.
Thank you, Janet. And sorry for the late late putting you on the spot there for the amendment that came in through the.
That's
email.
okay. That happens this time of year. I get it.
Representative McCray.
Thanks, Mr. Chair. Janet, so just to clear my head a little bit, we had the amendment you talked about first, and then this is a very different amendment that just came in that you just described. No?
So what I summarized in the bill analysis was there were some bullet points in Senator Rafferty's testimony. I tried to understand what he meant by them and put him in a little bit kind of a framework. I don't think I was wrong about it, but he didn't give language. He just said this is the kind of idea he had.
Okay. And then this specific amendment just came in from the sponsor.
Yeah, it came in through the testimony portal, so I don't think that could be considered confidential. So.
Right. And one more question, Mr. Chair.
Go ahead.
This may not be fair, Janet, because I mean, you're just amazing. But does this have the same constitutional concerns that you reviewed in the bullet points that you fit into sort of an amendment?
So it depends on what part you talk about. If you're talking about disclosing whether it was financed by a candidate, to the extent any of those disclosure requirements that are in current law are fine, I would think that they're fine here. The only question being, if the disclosure is going to take up almost all of your characters of your text message, that may be viewed as too much of a restriction or too much of an impediment. I am not an expert in this area of law about precisely how much you can put disclosure requirements on different communications. So I just don't know if that, because it might, I could imagine, be half of your message. You know, is that too much? So that would independently be one concern. And then secondly, even though it's very nicely and cleanly placed just in this political communication statute, I don't see why you couldn't, if you were somebody who really likes to influence elections, even if you're not associated with any party or anything else, you're just somebody who regularly engages in independent expenditures and really likes, you know, I don't see why you as an advocacy group wouldn't be able to try and raise the same argument that businesses, as far as I know, because I didn't see it under that federal law, they don't have to have an opt-out requirement. So why should you have to? So I don't see that as being different, although when I first saw it here, I was like, oh, that's clever, that takes care of it. And then I had to stop and think, wait, it's still targeting political messages in a way that isn't applied to other messages.
Thank you, Representative McCray. Senator Hickman.
Yes, thank you, Mr. Chair. Janet, you always never cease to amaze me with the thoroughness, even on the spot. And I have one of these too, and flip phone, just like your husband, Janet. And what happens is, no matter how long the text is, it just gets broken up, and it's like 5 texts instead of 1. So if anyone is interested in that amendment with all those disclosures, it wouldn't really matter. But I look at text messages in today's world like internet, like emails, because people are sending emails to people's phones that look like text messages and Facebook messages. And so it's all the same to me. And so it would seem to me that if we have those exemptions for internet and email communications that are less than $100, I just can't see that this bill, with all due respect to the sponsor, is necessary. But again, if we wanted to specifically say, and text messages in that area of law that exempts those expenditures under $100, then I guess we could, but I'm annoyed by them too. And I think that sometimes it would be nice to know where they come from. So I'm not opposed to a disclosure of some kind, but it just seems like there's a lot going on that would have to be checked before we were able to find some language that made the most sense that would still allow for the First Amendment to be intact. That's my position.
Thank you, Senator Hickman. Representative Corey.
Thank you, Mr. Chair. I get these things. I'm annoyed by them. I don't I don't like them, but I don't know if I need to make any special laws surrounding them. If there's a candidate that I'm kind of mediocre about, or even a candidate I like, and they continue to spam me, with text messages, I'm probably not going to vote for them, and I'm going to, take that action on my own. And if people don't disclose, who they are and they're sending me these messages, I'm probably going to ignore them and think they're stupid as well. So I don't know if we need a law to prevent this kind of thing. I think people have enough common sense to, see this. And if they don't agree with what they're, getting hit with, or they're not able to opt out, I mean, that's on the candidate, or that's on the political group, putting the messages out. So I'm probably not going to move forward with this. Thanks.
Thank you, Representative Corey. Senator Farren.
Hey, good morning, folks. Hey, listen, ditto to both my colleagues that spoke before, and nothing drives me crazier than when politicians say I have nothing more to add than talk for 10 minutes. So I'm going to make a motion of ought not to pass.
Second.
All right. All right. So motion ought not to pass by Senator Farren, seconded by Representative Kinney. So any further discussion? Representative Topeka. Oh, sorry, that was an error. Yeah, I'll just add, from a perspective, my other life is with GWI, which is an internet service provider. We're also a telephone exchange, and regulating phones is an FCC thing. There's preemption across the board there. So you could pass something that could probably be limited to the state. It would be very, very difficult to enforce, and you'd probably run into a lot of preemption on the federal level, I would assume, with that too. So as much as I'm equally as annoyed, I tend to take Representative Corey's route and just either block the numbers or take my vengeance out in other areas with them if at all possible. So I think I'm also going to be supporting the motion ought not to pass. So if there's no other discussion, looks like we have a quorum. We have 2 senators present, which is fantastic. Karen, we can call the roll when you are ready, please.
Senator Lucchini. Senator Lucchini absent. I can always come back to him if he comes on. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. Looks like Senator Lucchini is still out. So 1, 2, 3, 4. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So the motion ought not to pass is successful by unanimous of all those present. The 3 absentees have until noon on Monday, thank you, Representative McCrate, to register their vote. And that concludes the work session for LD 818. Janet, when you're ready to reset, can we move on to 1178, please?
So LD 1178 is a resolution proposing an amendment to the Constitution of Maine to prohibit the consideration of a people's veto at a presidential primary. So as the title suggests, this resolution proposes to amend Article 4, Part 3, Section 17 of the Constitution of Maine to prohibit the vote on a people's veto referendum from being conducted on the day of a presidential primary election. Just a reminder, because we talked about these earlier this session, for a constitutional resolution, the legislature has to vote by 2/3 vote in each chamber in favor of the constitutional resolution, and then the resolution would be submitted for ratification by a vote of the voters in the election held the following November. Because the governor doesn't have the opportunity to sign or veto the constitutional resolution, you're not able to amend it to include any statutory changes. During the public hearing, there was testimony submitted when I looked it over that talked about the timing and the way that the people's veto process works and the effect it has on the law that's the subject of the people's veto. So I thought I'd give a little recap of that. So this is a chart, if you've been in this committee before, that you've seen before, although I update it whenever I can. It's attached. It's the process for the people's veto referendum. On the second page, I highlighted some of the portions of the chart that talk about the timing. But just in summary, as the chart shows, when a people's veto petition, which is the part that has the collected signatures, so once we're at that stage, is filed with the Office of the Secretary of State, the effect of the non-emergency legislation or any portion of that legislation that is the subject of the petition will be suspended pending the outcome of the people's veto referendum election. So if you add up all of the relevant timeframes together, the people's veto referendum vote ordinarily will be conducted at a statewide or general election that occurs at least 180 days, which is about a half a year after the adjournment of the legislative session in which the legislation that was subject to the people's veto was enacted. So that, if you want to know where I came up with 180 days, so the petitioners have 90 days after the adjournment of the legislature to collect the signatures. Then the Secretary of State has 30 days in which to certify the petition and the signatures. This time frame could be extended if the Secretary of State issues a decision, and then there are some court challenges about whether the decision is correct or not. That has happened in the past. So that could extend that 30-day period, but just generally speaking, there's 30 days. And then the vote on the people's veto referendum has to be held at least 60 days after that final determination. So when you add that all up, you get around 180 days as a general rule of thumb, could be longer, before the vote would happen after the legislature adjourns. If the people's veto referendum does not receive a majority, the vote casts. Then the legislation or any part of the legislation that was the subject of the referendum does not take effect until 30 days after the governor's proclamation announcing the results of the vote. And just to remind you, under the law that was enacted in 2019, if any qualified party or parties certified to the Secretary of State by November 1st of the year prior to a presidential election that they have a contest among candidates, then the presidential primary will be held on the first Tuesday after the first Monday in March of the presidential election year. So as I see it, if the legislature adjourns around sometime before September, then that would be the type of a people's veto election that would end up maybe on the March presidential primary ballot, but that only happens every 4 years, as you know. If the adjournment happens around December or before December, between September and December, basically, then that would end up on the June primary election ballot if there is a primary that year. And then any other time that the legislature adjourns, but at least before May, then it could end up on the November ballot of that year. If you look at about half a year as being the time frame it takes to get to the ballot, if that makes any sense. And then we do have a preliminary fiscal impact statement because it's a constitutional amendment that's being proposed. We have the same statement we see all the time, which is if there's enough questions on the ballot in November that spills over onto a second page, then there'll need to be a cost of $172,000 for ballot printing and delivery for that second page.
Thank you, Janet. Any questions or comments from the committee? I guess I would have a question, and Janet, you may have walked us through that, but let's assume that we pass this resolution and we don't do citizen vetoes on presidential primary days. The earliest, if I understood you correctly, I think the earliest next statewide election would be the November election.
Depends on the year. So
Okay.
if there is a June primary, then that could be statewide. It could be a primary for governor. There could be a bond issue on that. So that would be a statewide election. So it could be June.
Depending on what else is in the queue for
Right. And if they're
voter issues.
exactly.
Okay. So earliest would be June. Latest, though, if there's nothing in June, the next regularly scheduled statewide election would be November. Is that fair?
Right.
Okay.
But it depends on how you're looking at it for earliest. So if there was a bill that was enacted by this legislature in the first regular session, which ended in March, those would end up in November. That would be a sooner election because it happened before May.
Yep. Okay.
So it really just depends on when the legislature adjourns. And, to talk about soonest is really, you've had a lot of special sessions lately. So you never know when you're going to adjourn.
Yeah. And my purpose is just trying to figure out what is the longest period we would go where the law would be suspended before the citizens would have a chance to weigh in. And if the veto failed, how much of a delay we would need to implement that legislation. That's really what I'm trying to figure out. What the longest delay could potentially be for that. So, Representative Corey. Sorry, Janet. Sorry.
I was just going to say it also depends on the litigation, because as we've seen in the past, there can be extended litigation on the signatures.
Mm-hmm.
So that can add a lot of time too. And I know in the last time there was a question, I can't remember if that was for an initiative or a people's veto, but in any case, they were right up against deadlines. Like, we need the court decision tomorrow or we can't make it on the ballot. The ballots can't be printed. So there's all that kind of stuff too.
Gotcha. Thank you. Representative Corey.
Thank you, Mr. Chair. I imagine that in the same year, and Janet can correct me if I'm wrong, in the same year that there would be a presidential primary election, there is going to be a June primary because that's when all of us are on the ballot. So we'll definitely be having, Senate and House primaries in those years because we go every 2 years.
Okay. Thank you, Representative Corey. Any other questions or concerns, comments from the committee? Do we want a motion? Representative Kinney.
Thank you, Mr. Chair. I'd make a motion ought to pass as amended because I know we need a fiscal note.
All right, so let me see. Motion by Representative Kinney. Is there a second?
Second.
I'll second.
Second by Representative Dolph. Any question, comment, further discussion? All right, seeing none, then Karen, when you are ready, please, we are ready to proceed with the roll.
Senator Lucchini. Senator Lucchini, absent. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
No.
Representative Chiazzo, no. Representative McCray.
No.
Representative McCray, no. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
No.
Representative Riley, no. Representative Supika.
No.
Representative Supika, no. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. 6 in favor of the motion, 4 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So the motion ought to pass as amended is successful. The 3 absentees have until noon tomorrow to cast their vote. Sorry, noon on Monday. Looking at Representative McCray, noon on Monday to pass their vote. Thank you. All right, moving on. Can we take up LD 1621 next, please? And I know you guys all have to reset, so when you can.
Wait a minute. The minority report is ought not to pass.
Oh, sorry. Thank you. I always forget that.
I know you do.
I'm comfortable with ought not to pass. Anybody else on the minority wish something different? You want to rattle off who was on the? All right, everybody's good. Everybody's good with ought not to pass. Okay. Yes. Minority report ought not to pass, please. Thank you.
Thank you.
I'll get that right on the last day, Karen. I promise. Or it'll be next session, something like that.
I feel better already. We have a chart. So LD 1621, excuse me, is an act to reform payments to legislators by political action committees from Senator Maxman. So the bill repeals and replaces Section 1054B of the election laws, which is the law restricting payments to legislators and their businesses by a political action committee for which the legislator serves as a principal officer, treasurer, primary decision maker, or primary fundraiser. So the middle column here will show you what current law provides, and the right-hand column shows you what LD 1621 would provide instead, because it's a repeal and replace. So it involves the same type of political action committees. Again, as I mentioned, if the legislator is a principal officer, treasurer, or an individual primarily responsible for fundraising or decision-making, then that is a political action committee that's affected by the bill, or even by current law. Under current law, such a PAC is prohibited. So these are the prohibitions, this next row across. So it can't compensate the legislator for services provided to the PAC under current law. Also under current law, that type of PAC can't make any payments to or distributions, loans, advances, deposits, or gifts of money or anything of value to or compensation to a business owned or operated by the legislator. In addition, under current law, the PAC can't provide any reimbursement for expenses that the Ethics Commission determines are for the personal financial enrichment of the legislator. So under the bill, the prohibition on compensation for services and on any kind of money sent to a business owned or operated by the legislator, both of those are extended to an immediate family member of the legislator as well. In addition, if the Ethics Commission determines that some kind of reimbursement would be for the personal financial enrichment of an immediate family member of the legislator, that would also be prohibited. So remember, whenever I'm talking about the legislator here, I'm talking about the legislator who is one of these things for the PAC. So it's not as if Representative Chiazzo establishes a PAC and then it can't pay Senator Hickman. This is about your own involvement in the PAC. And then the bill also newly adds a prohibition on reimbursements for any expenses that are or will be reimbursed by the legislature or any other source of payment or reimbursement. So if you are a legislator and you have a PAC that you're the principal officer for, they can't pay you for something that you're also getting paid for in your expense reports that you file with the legislature. As far as authorized payments, there are some authorized payments under current law, but they're down here in the chart because they match up with something. But so don't think that there's nothing in current law. We just haven't gotten there yet. But under the bill, there's a new provision that allows the PAC to pay for directly or to reimburse the legislator for travel expenses that are incurred in the proper performance of the duty of the legislator, so your own legislative duties, as well as for conducting activities for the PAC, including the cost of fuel for the use of the legislator's vehicle, but not including the cost of repairing or maintaining the vehicle or the cost of any non-necessary vehicle accessories. Now, as far as authorized payments that are under current law, the PAC can pay the legislator for the expenses incurred in the proper performance of the legislator's duties. That is continued. For purchases on behalf of the PAC, that's continued as well in the bill. And then for travel expenses associated with volunteering for the PAC, and that's continued in the bill. Some other prohibitions. So under current law, the PAC's funds may not be commingled with the legislator's personal funds or the funds of the business owned or operated by the legislator. Under the bill, that would be extended to commingling of funds with anyone's personal funds, not just the affected legislator. And then the commingling the funds of any business, not just the legislator's own business. The penalties under current law are somewhat unclear. If the PAC makes an expenditure that's in violation of campaign finance laws, and that actually is true for any PAC, if it makes any expenditure in violation of campaign finance laws, including this provision of current law, it commits a Class E crime. But the word expenditure is a defined term. We just looked a little bit at the definition this morning as far as traditional campaign finance, but in 1052 of Title 21A, you have the definition applicable to PACs. And that definition is limited to payments made to initiate or influence a candidate or ballot question campaign, or the transfer of the PAC's funds to another candidate or PAC. So as I read current law, if the PAC makes an expenditure to the legislator that is not related to influencing a campaign, or that is made when the legislator is not actually a candidate, then it would be unclear to me that even though it's prohibited by current law, it's not clear to me that that Class E crime default penalty provision would apply. So under the bill, there's a very clear violation scheme. So it says that the legislator or PAC that violates this section is subject to a penalty that's a greater or up to a $500 fine, or the amount of the impermissible payment or reimbursement. There is a technical drafting issue with this, but at least the violation provision is clear. As far as rulemaking authority, Title 21A is not a title that has sort of a default, you Ethics Commission or you Secretary of State can make any rules necessary for anything whatsoever. So it's not clear to me that there is rulemaking related to this provision of current law, but the bill would clarify and state affirmatively that the Ethics Commission could adopt routine technical rules regarding record keeping and reporting requirements related to these provisions and travel and vehicle reimbursement rates. So I did have a few technical drafting questions about the way that the bill is drafted. It's maybe a little easier to understand if you see the bill itself, this first question. So there are limitations about the types of travel expenses that may be reimbursed that exist in one provision of the bill. So it says you can pay fuel costs, but not maintenance or accessory costs. And it's not clear to me if those types of definitions of what travel expenses can be paid are supposed to apply to the next paragraph of the bill, which talks about payments to legislators for travel expenses associated with volunteering for the PAC. So I just want to show that to you. Oh, I didn't hyperlink the bill. That was not very wise of me. Well, I can show it to you if you ask me to. But it's the difference between paragraphs B and C of the bill, if you have it in front of you. One of them talks about paying the legislator for travel expenses, included those for conducting activities for the PAC. That has all the clear limitations about fuel versus accessories. Paragraph C talks about travel expenses for volunteering for the PAC, which I don't precisely know how that's different than conducting activities for the PAC. But that travel expenses provision is not limited to just fuel, but not performing maintenance, etc. Then there's the question that always comes up this year if we're talking about PACs. So as drafted, both current law and the bill apply only to a political action committee with legislators in certain leadership positions. It's unclear to me if you would want to intend that the bill's prohibitions would also apply to some or all ballot question committees that have legislators in certain leadership positions. part of the reason I brought this up is it was brought up in a work session on an earlier bill that some people wanted to consider doing that. So just a reminder, under current law, so the provision that is repealed and replaced, the way it currently operates without respect to any other legislation that might be enacted or might not be enacted this year, the definition of a political action committee includes some persons who influence ballot question campaigns rather than candidate campaigns. If LD 1485, the way that you all have agreed to amend it, is enacted, however, a political action committee would only have to do with influencing candidate campaigns. All of the types of political action committees under current law that have to do with initiating or influencing ballot question campaigns would now be considered ballot question committees. So you, through LD 1485, if that were enacted and this bill were enacted, you are changing the scope of the type of PACs that are involved. And so that's just something to consider. And then also, although the violation provision is very clearly drafted to say that a legislator that violates the section is subject to the penalties that are provided, if you actually look at the language of the section that comes before the violation, it only talks about a political action committee not being able to do certain things. So it can't make a compensation to a legislator in certain circumstances. That is not written as, and also the legislator may not accept the payment. So it's not clear to me that other than commingling funds, how a legislator could violate the provision. So if you want to apply it to a legislator, we just have to either amend the penalty provision some way or amend the language before. I could look at that and figure out which way is best, but it would need some changing of language, I think, to make it clear that a legislator accepting money, if the PAC can't pay that money, is also a violation. It's not just the PAC paying the money that's a violation. This is the one time I didn't hyperlink the bill, the one time I needed it. That just
It's Friday. It's okay. I think we're getting there for sure. Any questions or comments from the committee? Representative McCray.
I'm on the question that Janet raised about ballot questions. I don't know the answer, but do we want to request the sponsor weigh in on that? I guess I would like to request that.
Thank you. Yes, I will bring in Senator Maxman then. I see her in the waiting room, so let's give her a second to beam in and get acclimated. Good morning, Senator Maxman. Welcome.
Good morning.
Representative McCray, did you want to? Sorry, hold on. Sorry, Senator Maxman. Did you want to specifically ask Senator Maxman a question, or did you want to just give her the opportunity to respond to Janet?
Yeah, basically, I was interested in if Senator Maxman wanted to comment on what Janet raised about how this would affect ballot questions or not.
Thank you.
Could I get another 2-second summary on that point?
Sure. I didn't go through it too much because we talk about it in here a lot and I didn't know how much people wanted to listen to me. So I did not really explain it and I apologize. So under current law, the way that political action committee is defined, so it applies to the current prohibition on all these payments that you're repealing and replacing. So that current law says that a political action committee, includes a separate and segregated fund, for example, of a corporation, even if their purpose is to influence or initiate ballot question campaigns. And it also includes other persons, which just, so any kind of individual or committee or organization is a political action committee if it receives or expends more than $1,500 in a calendar year for the purpose of initiating or influencing a ballot question, as long as that's its major purpose. So whether you remember all those details or not, the point is current law applies to some ballot question committees. They're not defined as ballot question committees, but you might think of them in the vernacular as a committee involved with ballot question campaigns. The committee has another bill before it that they voted in favor of unanimous committee amendment that would change the definition of PAC to only really be involved with committees and organizations that are raising money and expending money to influence candidate campaigns. And any other kind of committee, if it's just having to do with ballot question campaigns, that would be considered a ballot question committee. So it's going to realign the definitions. And by doing so, it takes those ballot question committees out of the purview of this law. Whether your bill passes or not, they're not going to be covered. And so that is one question, is do you want to maybe not allow that change? But then secondly, even more broadly, the committee had discussed when they were talking about that other bill, whether they want all ballot question committees, whether they're under the current definition of PAC or not, whether maybe all of them should be involved in this prohibition if a legislator established that ballot question committee. So there's the narrower question of the change from LD 1485, and then the broader question of ballot question committees generally.
Thank you. That was really helpful. I think I wouldn't want to go against the work that the committee has done on previous bills. My inclination would be these seem like pretty common sense, clean reforms to me, and my inclination would be to apply them to the other PACs, but would also very much be interested in hearing the committee's thoughts on this one.
Okay, thank you, Senator Maxman. Senator Hickman.
Yes, thank you, Mr. Chair. If I may ask a question of the bill sponsor, Senator Maxman, can you speak a little bit? I don't know if you've heard all the analysis or need Janet to put it back up, but there is some technical stuff around travel expenses versus maintenance. I think you and I spoke about that briefly as well. So I just want to know where you land on those issues that are brought forth in the bill analysis.
Thank you, Senator Hickman. My intent was with the bill was to allow reimbursement for gas, but not other expenses that could extend beyond simple legislative activities. So just limiting it to gas reimbursements as a permissible use of the PAC funds.
So would
Janet,
you, oh, I'm sorry.
Oh, sorry, Senator Hickman. No, you go ahead, follow up, please, sorry.
So I guess, so my question is, when I think of how, say, on a tax form, you can deduct or take a claim against a business expense that's either actual cost or mileage. And I guess I'm wondering, are you trying to exclude mileage reimbursements from this law? Meaning that if a leadership PAC legislator who is driving around the state to help with campaigns and other matters is keeping track of their mileage, but not necessarily their gas costs, are you trying to make a difference between those two things in this bill?
Not intentionally, no. I think the bill language references mileage reimbursement, which was my intent.
Okay. Thank you.
Thank you, Senator Hickman. Janet, did that get to your question about the technical issues on travel? Because it sounded to me like it was a question of, I had my notes as applies to legislators as volunteers. I don't know, did that answer your question on the technical side for?
It's so not really, but for two reasons. So, and I did just call up the bill so I can show you all what I'm talking about. So I'm going to try and blow this up because it's kind of closely written here. So we're looking at the difference between paragraph B and C. So I just want to get at the mileage part that was just discussed and setting aside my issue for a second. So we just look at B. It says the PAC may pay for or reimburse the legislator for travel expenses, including the cost of fuel for the use of the vehicle, and then excluding the cost for repairing or maintaining the legislator's vehicle, and then any accessories. So I don't think that talks about mileage reimbursement, although there is a discussion of mileage reimbursement in the rule making provisions. So it does allow the Ethics Commission to talk about vehicle reimbursement rates. So Could be that there was just some disconnect in drafting, that maybe this is what it sounds like the sponsor wanted. Some kind of mileage reimbursement would be fine, but that's not what it says, because it's my understanding, very limited, that mileage reimbursement rates are about fuel and maintenance being wrapped into one. They're not just about fuel cost. So that's easy enough. We can change that. It can be changed to write whatever you want it to say. So that is that question from Senator Hickman. As far as my question, if you look at this whole paragraph B, which discusses what kind of travel expenses can be paid and what can't be, which can be amended however you want, it talks about those expenses incurred in the proper performance of the duties of the legislator and for conducting activities for the PAC. Then if you look in C, which doesn't have anything about fuel and maintenance of vehicles or accessories, it says that the PAC may pay for or reimburse the legislator for other expenses incurred in blah, 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 and for travel expenses associated with volunteering for the PAC. So this travel expenses for volunteering, how does that relate to travel expenses for conducting activities for the PAC up here? So I would suggest, it sounds like what the sponsor is saying, whenever it's talking about travel expenses, she wants these kind of restrictions to apply. I would just get rid of this phrase from C, if that's what you all think.
Okay. So remove 22 and 23.
Just that phrase, the travel expenses phrase from there.
Okay. Senator Hickman.
Yes, thank you, Mr. Chair. So I would suggest that in paragraph B, we clarify that the reimbursement to the lawmaker for travel expenses is in the form of a mileage reimbursement. And then we do have to, I think, eliminate language that says you can't reimburse for the cost of repairing a vehicle, because that is included in a mileage reimbursement, but only in the mileage reimbursement. And so if we want to leave that language there, I guess it should just clarify it, for instance, just because of the issue that came up. The lawmaker can reimburse for mileage, but the lawmaker cannot pay for tires in addition to that and get paid for that. Yeah, so I don't know how that language should read, but I think that that's what I would like to see. And if the Senate sponsor thinks that that's disagreeable, then we can talk about it. But I want to make sure that you can reimburse for mileage if you keep track of it in the rules, but you can't necessarily reimburse for tires or for, a damage to the vehicle in a car accident or any of those kinds of things. Oil changes, that's all incorporated in the mileage reimbursement. And I guess I want that section B to make that clear.
Janet, and I guess this will be to Senator Hickman as well, does it make sense to just exclude direct maintenance costs? So like if somebody tries to submit a cost for tires or even gas, right? I mean, typically in a business, you have two choices. You can go direct expenses or you can go mileage.
Correct.
And if you go direct expenses, I give you a receipt for $10 in gas, you give me $10. If I go mileage rates include multiple things associated with maintenance, gas, regular work, everything else, right? So yeah. Would you prefer just like removing the direct expense piece and just limit it just to mileage? Does that make sense?
I think that, are you asking that of me, Mr. Chair? I'm sorry.
I'm just asking if that clarifies your position, that's all.
It does clarify my position. I think that mileage is all encompassing, that you cannot reimburse yourself for mileage and reimburse yourself for gas, and reimburse yourself for tires, and reimburse yourself for any other vehicle expense while using your vehicle to perform the duties of the PAC. That only mileage can be reimbursed. That's it, full stop. And if the commission is going to write rules, the commission can say, is that mileage reimbursement rate going to be the federal rate? Is it going to be set in the rules just by the state? Because those are two different things. And that the rules can make it very clear, I suppose, that that mileage reimbursement cannot include any of those other actual costs of using the vehicle while performing business for the PAC or in the proper performance of the duties of the lawmaker, because both of those things are important. And I do say that we must clarify that, yes, you cannot reimburse yourself twice for something that you are going to get reimbursed for by the state and something that your PAC is going to reimburse you for. You can't do that twice. So there has to be some record keeping to make sure that we can see, and this may be for rules, that if the lawmaker is reimbursing themselves for mileage and the proper duties of their job, that they're not double dipping, meaning that if they're going to take the reimbursement from the state for the mileage that we all are reimbursed for, that they can't also reimburse themselves for that mileage under their leadership PAC. I hope I've made myself clear.
Janet, are you okay? Is that making sense to you're taking a lot of notes? I see that. Okay. Representative Corey.
Thank you, Mr. Chair. This bill, it's funny, it kind of reminds me a lot of the cell phone bill that we had earlier, and I'll sort of explain sort of where I'm at there. We had an issue, a few years back where we had a legislator that was using their PAC money, to travel pretty extensively and go to Starbucks and all of that other stuff. I don't know if anybody remembers that or not, but that's the way they were using their PAC money, and we had somebody, and I'm guessing this whole tires thing, comes down to, somebody that used their PAC money in this way. But, the reality is that I think that when this stuff happens, it kind of delegitimizes the PAC or, the actor, do you know what I mean, on its own. I'd be a lot less likely, not that I don't give to PACs, but, I'd be a lot less likely to give to a PAC that I knew the money was being sort of misappropriated along the way. That I'm not sure that what we're trying to do here, and we could certainly do this for a lot of things, a lot of expenses by a PAC, but I don't know where I want to go on this. I really don't right now.
Okay, thank you, Representative Corey. Representative McCrate.
Thank you, Mr. Chair. To Senator Hickman's point about not getting reimbursed twice, I'm just wanted to clarify that paragraph D, to me, that clarifies that, and maybe that's a question for Janet. It says the political action committee may not pay for or reimburse the legislator for any expenses that have been or will be reimbursed by the legislature or any other source. So I don't know if Senator Hickman's still here, but to me that makes that point. Yes, thumbs up. Thank you.
Okay.
Which I think is a really important point, and it's there, so that's great.
Okay. So Senator Hickman, if I understand correctly, you're regarding your question about direct reimbursement versus mileage, you would like to propose that the PACs only reimburse for mileage, that the user has to keep records, and they're not going to be allowed to reimburse for direct expenses like for tires or $10 worth of gas. It's going to have to be out of the mileage form.
That is, Mr. Chair, that is correct. And okay. I don't know how we want to write that, but that should be clear in the statute, and then it can be clarified further in the rules, I guess.
Sure. And if possible, maybe we'll bring in Director Wayne next to see if he has any thoughts on if there's I can't imagine it would conflict, but I don't know what I don't know. So we'll bring Director Wayne in and see if he has any concerns or challenges with going that route. Good morning, Director Wayne.
Good morning.
I'm sure you've been listening, but we can rephrase the question if you'd like.
Well, no, I just have a couple more. I think I have an answer or just a couple thoughts on the travel. I mean, first of all, I did want to mention that just as background, for what it's worth, Maine Clean Election Act candidates generally cannot have a leadership PAC. I just think it's good to always remember that in the background. And I also wanted to mention that I don't know that this is common, but if a lot of times if legislators need to go to a conference that involves travel other than with their vehicle, oftentimes it's sponsored by somebody else, but once in a great while, at least, they might want to use their PAC. So there is some like airfare that some legislators will turn to a PAC for reimbursement. That's good to keep in mind. And then on the issue of how the sort of the rate and how they're reimbursed, we see all sorts of people who are engaging in political and legislative business being sort of reimbursed for travel in different ways. If it's a Maine Clean Election Act candidate, we have a highly regulated system where people have to keep records of their vehicle travel based on numbers of miles, and they have to show that the reimbursement is more than a particular rate based on the number of miles. The only thing I wanted to add to the discussion, I'm not at all trying to disagree with Senator Hickman, but I just wanted to raise the point that some people find keeping travel numbers of miles to be burdensome, and so not everybody wants to engage in that level of record keeping. We think it's appropriate when public funds are being used, but it's just a thought. It's just sort of a balancing of this is PAC money, so do you think it's reasonable to ask? I think we're fine with whatever you want to do, but it's just these aren't public funds. It adds a level of administrative work in order to get reimbursed for your travel. You might think that's totally appropriate for a leadership PAC, but it's just something to think through. Thank you.
Okay, thank you, Director Wayne. Senator Hickman.
Thank you, Mr. Chair. Yes, there does need to be an inclusion of travel expenses that are not related to mileage, which have to do with traveling for conferences. I definitely forgot about that. As far as the mileage requirement, I mean, I don't have a smartphone, but I can say that when I did travel around the state for my leadership PACs a couple of years back, these smartphones do it all. You don't have to keep records because your smartphone is going to tell you exactly how many miles you have traveled here or there. It's in it, and you just have to find it. And that was the way in which I was able to use that to come up with the mileage that I was reimbursing. The PAC was reimbursing me for. So I don't think it's a burden on the user of a leadership PAC to be able to keep track of their mileage. That's just my opinion. If the committee wants to go a different way, fine. But I think that if we make it clear that, use of vehicle, mileage reimbursements only, and then other travel expenses for other things, hotel rooms and airfare and train fare to go to conferences and put yourself up, you can also do with your leadership PAC, should be made clear that that is allowable in the allowable expenses. So I hope that clarifies what is true for how people should use their leadership PACs in a responsible and ethical way, whether they're clean elections candidates or not. I mean, you can't have a leadership PAC if you're a clean elections candidate, but I don't see any reason why all lawmakers shouldn't adhere to the same principle.
Thank you, Senator Hickman. Any other questions or comments? Senator Hickman, did you have a follow-up? Your hand's still up, sir. No, okay. Okay, seeing none, any further discussion from the committee? Representative McCray.
Well, if you're ready for it, I'd like to make a motion ought to pass with amending the language we've talked about in B to make it clear that we're talking about mileage. And leaving in the travel expense part, as was pointed out, there could be times when that's appropriate, but you document it.
And you're okay with leaving in the ballot question section as well, applying to ballot question committees?
Well, that's a good question. I appreciate what the sponsor said. She doesn't want to interfere. She would like to see it included here. I guess I would ask where other people are on that particular one. I think it makes sense to include it, but not to create conflict.
Okay, Senator Hickman? You're muted, sir, I'm sorry.
I think it makes sense to have consistency between any kind of political action committee that is trying to influence any kind of election. So I don't know how that needs to be written in the law, but I think that it should be consistent.
Okay. Janet, do you have enough info for the technical issues to clarify those, or do you need more info? Oh, Janet, now you're muted. Sorry.
Just want to be clear. So does that mean, Representative McCrate, you do want to include all ballot question committees?
I would say yes, unless that's a deal breaker for people.
Okay, and then the last technical issue about violation by legislators, do we just want to find the PAC and the ballot question committee themselves? And the legislator only for commingling funds, or also the legislator for accepting the payment?
I'd say both. No, Craig's saying no.
Senator Hickman.
I mean, Senator Hickman, sorry.
Yeah,
Okay.
Senator Hickman, go ahead.
I guess it's not a strong no. It's just about who's responsible for breaking the law here. So if a legislator receives money that they don't know is actually not supposed to come to them, other people can weigh in on whether or not they think that's an okay thing to charge to the legislator. That's all. I just don't know that that is true in any other aspect of law, except for maybe, well, I won't say. There are some laws where the recipient of the bad behavior is also charged with the crime, but I don't know if that applies here or not. And so I'll just go with the will of the committee on that particular technicality. And I was wondering if maybe the bill sponsor had an opinion about that as well.
All right, let me get to Senator Maxman in just a second. Representative Kinney's had her hand up for a little bit, so I want to recognize Representative Kinney.
Sure. Thank you, Mr. Chair. I may have missed it. I didn't hear a second.
There is no second yet. We're still discussing. She hasn't formed the official motion yet.
Okay, thanks.
Yeah. Senator Maxman, did you want to comment on the issue of including the legislator and the penalty as well, the receiving legislator?
That makes sense to me, but I have no strong opinions on it.
Okay. All right. Thank you, Senator Maxman. Do you have enough, Jay, then, to form your motion?
Okay, so.
Can I have a question for Janet?
Sure.
On the point of, thank you, on the point of giving and receiving and both being responsible, is that inconsistent with other places in law? I really appreciate Senator Hickman's point, but I guess I was picturing you would ask, where's this money coming from? But
So I want to help you get where you want to go. I'm trying to be very nonpartisan about doing it. So give me a second. Maybe I'll just read to you some of the provisions and you can decide, should the legislator or the PAC or both be in charge or responsible for a violation? How's that work?
Perfect.
That way I can be very nonpartisan, just let you all hear it.
Perfect.
So paragraph A is about compensating the legislator or immediate family member for services to the committee, as well as compensating the business owned by the legislator or immediate family member. So how do you want those to apply?
Anybody?
I'm not sure what you're asking. Sorry.
So I think you may, if you look at these paragraphs, want to treat them differently with respect to who's responsible. Maybe you won't, but just based on a comment I heard earlier, you may want to treat them differently, but I don't feel like I can guide you. So I'm just going to ask.
In each one of those instances, we're going to say one or both, right?
Right.
That's what you're
asking. Do you
asking.
want it just a PAC to be responsible or both?
Yeah.
Got it.
Representative Dahl.
I can't tell if I'm having my own idea here or not. So I just don't want to.
Sorry, Representative Dahl.
Oh, thank you, Mr. Chair. The only thing that I'm thinking in regards to family members or married, not everybody is. You may have a live-in boyfriend, so I didn't know if it could be added as your significant other. Also, I don't even tell you the truth. I don't, right at this point, I'd have to see it all redone so I understand exactly what we've taken out, what we're putting in, what we, include and exclude.
Yep.
Because I really trust the Ethics Commission to watch these things, and they've caught a few things themselves, I just don't know if we really need all of this right now. But that's my opinion. I'm listening, I'm taking notes, but when it came to that family part, being married or a family member, significant others are families, in my book anyway. And two people don't have to be married to be a family. That's just my input on it all, and I'm trying to figure it out. Thanks.
Thank you,
I did
Janet?
just find the definition that applies, so I want to show it to you.
Thank you.
So this is Title 21A, Section 1, so it applies everywhere in the title. And sorry, my screen is being covered up by some of your faces. So immediate family means the spouse, parent, grandparent, child, grandchild, blah, 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 lots of people, including your in-laws.
Half brother, half sisters. Yeah,
Wow.
Yep.
long list.
Guardian, former guardian, domestic partner, half brother or half sister of the spouse, or the spouse of the person's half brother or half sister. Wow, somebody really thought these things through.
Yeah.
So it does include domestic partner. If that addresses your concern, I don't know. There may be other people you're concerned about.
Does that help,
I hope
Representative
it
Dahl?
would. Thank you very much, Janet. Yes, thank you very much.
Okay. Senator Hickman. Oh, sorry. Senator Hickman, did you have your hand up? Please.
Thank you. Yeah, yes, thank you, Mr. Chair. And just I wanted to say to Representative Dolph, yes, the Ethics Commission does a great job, but I can say, having had a leadership pack and more than once used it, we self-police. And I think most of the provisions that the senator has put forward they're good ideas, because it clarifies that a leadership pack for a lawmaker is not just a slush fund to be used for whatever. And I think that that increases people's trust in us as lawmakers who may be receiving money from places that folks might not want us to receive money from, but that are not disallowed at this time under the law. And so the more clarity that we can give to the Ethics Commission to monitor sort of the way in which they review campaign finance reports from leadership PACs, some of which have an extraordinary amount of money in them, I think is really good, because then everybody is on the same playing field and are under the same expectations. And it keeps journalists, or even us, from picking and choosing which campaign finance expenses and payments to other people are going to be the subject of hit jobs, attack ads, and whatever else. And so I think we do need some more clarity in the law, and I think that this bill is a good way forward with that. So if I may, on the question of should the legislator who receives money be fined, I think that they should. And I thought about this as well, which is, even in a traditional candidate campaign, if you receive money from an entity that you know you're not supposed to receive money from, it's up to you to figure that out and make sure that you don't receive that money, or that you give it back because you're not supposed to receive it. And so it creates accountability across the board. If a lawmaker is receiving money from a leadership PAC in a way that is not allowed by this update to the law, then I do think that that lawmaker might need to be reprimanded. So, or at least held accountable for that in some form or fashion. So I guess if Janet wants to keep going through both or one, we can still do that, but I'm not opposed to having the lawmaker who is receiving money wrong to also be reprimanded by the Ethics Commission if they catch it.
Thank you, Senator Hickman. Representative McCray.
Thank you, Mr. Chair. Janet, I guess I was assuming that number 2 covered everything that was in number 1. And it says a legislator or political action committee, which would do what Senator Hickman was just talking about. And it doesn't require a penalty. It may be subject to a penalty.
So the problem is the way section 2 is written. It says a legislator that is found to be in violation of this section. So you can't violate this section as a legislator if the only thing that's prohibited is the PAC making the payment. So if I say it's against the law for somebody to wear green t-shirts, the green t-shirt didn't violate the law, the person put it on did, right? So if the prohibition is a PAC can't compensate a legislator, maybe it's clear and everybody would interpret it that way. My only suggestion was, if you want that to be clear, let me rewrite it a little bit, make me feel better. If it doesn't bother you, we'll keep it the way it is, but I just don't think that is as clear as it could be.
I would say what you want to do with drafting sounds good to me. You know what the...
Yeah, I just want to draft it to say what you wanted to do. And it sounds like what you wanted to do is to capture the legislator for receiving any payment they shouldn't have.
I think so, unless others have strong feelings.
Representative Dolph.
Thank you, Mr. Chair. In regards to that, what Representative McCray brought up, for a person receiving the money to be also penalized, what if that person doesn't realize that they're not supposed to receive that money? Is that really fair to that candidate? I mean, to be a candidate, we're supposed to know any and all places you can or cannot receive money from? Because I don't think that would be really fair to penalize the candidate that took it if that candidate didn't know it was okay or not. Thank you.
I think I understand your point, Representative Dolph, but I think, you know, the old adage, ignorance is no excuse of the law. And I think to Senator Hickman's point and Representative McCray's point of having accountability, I guess, on both sides, I would be comfortable with that. I mean, I think as long as it's not overly burdensome, and it sounds like, you know, if somebody knows that they use the funds incorrectly, or they disperse the funds incorrectly and they use them incorrectly, that seems like a pretty clear violation. It doesn't sound like it's somebody that's, you know, they're receiving thousands and thousands of $100 checks into their PAC and they haven't had time to filter through all of them, I guess. So I wouldn't have a problem supporting that, just as a way of accountability across the board. And, you know, I think I have full faith that Director Wayne and the Ethics Commission will be reasonable in their rulings and not be overly burdensome or overly, you know, restrictive in it, or overly strong in their. I think they'll be fair. I'll leave it at that. I think they'll be fair and mindful if they have to make any rulings like that. Any other, Senator Hickman, your hand is up, sir.
Yes, Mr. Chair. I just wanted to say that Director Wayne and his staff are very fair people. They don't do gotcha with these campaign finance reports. They might ask you to correct something that you did wrong. Obviously, if you keep doing something wrong, then you may go before the commission's board to have some type of action taken if someone complains enough or if they find it themselves. But they're fair. And I think that with clarity, they can even do their job more fairly.
Thank you, Senator Hickman. Representative McCray.
Thank you, Mr. Chair. Can I ask a question through the chair of Representative Dole?
Sure.
Representative, is that issue a deal breaker for you? Are you in support other than that? Because if that's if that makes the difference, I think we should reconsider that part. But if you're okay with it and everything else, I think we could move forward. But I want to get your opinion.
Representative Dolph.
Thank you, Mr. Chair. Representative McCray. I don't like it, to be honest with you. I don't even know if I like this bill altogether, if you want to know the truth, because I guess I'm too naive, that I trust people, I believe in people, I believe in our ethics committee. We've left a lot of things up for their judgment, and they've always been right. And if there's issues that have been brought to their attention, or they've caught something, they've investigated it, and people have taken care of. I think because of an instance or two, that now we have to browbeat and put in more laws. And to me, it's sad. That's all. And right now, Representative McCray, I am really confused on what the bill actually says now and what it does entail, because of everything we've pulled and added and taken and questioned. And so I'll just keep listening. And when I see it all final, but in my heart, I guess I trust people to be good people. And I trust our ethics to all of us.
And I appreciate Representative Dolph too. There's an old adage that says, laws just keep honest people honest, right? And I think in this instance, I see this more as not creating new rules or requirements, restrictions, but really just kind of fine tuning what we already have in place, and maybe giving the ethics committee a little bit more guidance and help in evening that playing field between clean election people who don't have leadership PACs, and basically making it fair across the entire spectrum, if you will. So, but I hear what you're saying. It's a shame that we have a bureaucracy with lots of rules, but Janet earns her pay every second of cross-referencing bills and making sure there's no conflicts and things like that. So I hear your point, but I think this is just really just kind of fine-tuning in and tightening up what we have, not necessarily creating a new law or a new statute or something. But so please, you wanted to respond?
Yeah, thank you, Mr. Chair. See, that's some of the issue that you just brought up, is making things fair. And you're talking clean elections versus traditional. Well, the way those two run, they run totally different, but with the same ethics involved. And where I've always ran traditional, and I'm going to say this, and I firmly believed it, because I remember when the clean election law came out, I said, that's not fair to taxpayers to pay for a candidate they don't even want. So that's my personal feeling. And that's why it's very hard to run traditional and make the kind of money that a clean election candidate can get. So to me, that's part of where it's fair. If you want to run clean election, go ahead. But I know my opponent raised a lot more money than I did. But I won't take taxpayer money. And that's my personal belief. But trying to align a clean election with a traditional election, sometimes they just don't together.
Yeah.
Thank you.
Sorry, I didn't mean to confuse you, Representative Dolph. We're not trying to align anything together. This is just relating to PACs and ballot question committees. It says it doesn't have anything to do with clean elections, other than the fact that a clean election candidate is not permitted to have a leadership PAC. That's the restriction for clean elections, and that's it. So this really it would only impact clean elections in terms of the candidate's inability to even participate in a PAC, leadership PAC, if they choose to take clean election money. So I apologize if I confuse you. I'm not trying to align that. We're trying to make the leadership PACs and the business, the ballot question committees to be, basically to have the level of scrutiny and oversight that makes people comfortable that they're not misappropriating the funds that are entrusted to them. That's all. So, Senator Farron, sorry, you've been patiently waiting with your hand up.
No worries. So a couple things from my perspective is that I'm with Representative Dolph just from a standpoint of I really, regardless of where my views on this is, I need to see the entire language. We've changed this bill around and really moved a lot of things around. So if we move forward, even with amendment and a vote today, I'll be voting no, just because I got to see the whole thing laid out in front of me. Second of all is I understand the intent, but I just chuckle because we in Augusta get so wrapped up around the axles, and we think that everybody knows all of this stuff going on. People are busy leading their lives and being involved in stuff, and they don't know the difference between a candidate or a pact or a ballot question thing. We're supposed to be citizen legislators. We're supposed to have full-time jobs and lives, and we make this stuff so complicated. Who the heck would want to get involved in it? And we keep adding more of this stuff to it. Drives the normal person out. Why would you even consider having a leadership pack if you was a normal person? And we're going to make it even more difficult. And I struggle with that, because we are supposed to be citizen legislators. And part of the problem that's come to it is the amount of money, whether you're clean, traditional, whatever you want to call it. When you can get $60,000 running for a job that pays you $12,000 a year, whether you raise it through taxpayer money or through traditional means or ballot questions, the $10 million we're seeing on some of these. And we wonder why we have to have these conversations, because of the amount of money involved. But I look at this specific one here and say, if you are a first, a second term legislator, and you're just down there and you're trying to figure things out, and you want to talk about doing a PAC and maybe getting involved in leadership, and you look at how difficult we make it, I'd say no. And then we wonder why we don't get people involved. So that's my editorial and where I stand right now.
Thank you, Senator Farren. Senator Hickman.
Thank you, Mr. Chair. I motion that we table this bill.
Okay.
Second.
I heard Representative Corey first, so all right. So motion to table ends debate. It is a non-debatable motion. It was forwarded by Senator Hickman, seconded by Representative Corey. And Karen, when you are ready, please call the roll.
Senator Lucchini. Senator Lucchini absent. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Oh, I was on mute. Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dalla.
Yes. And thank you.
Representative Dalla, yes. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So the motion to table is unanimous with all those present. We will table that for a later date. Up next, Janet, when you're ready, let's move into 479, please.
Hey, it doesn't look like the GOP is going to support this. So basically,
Well, LD 479 is an act to ban foreign campaign contributions and expenditures in main elections. We've had, I think, 4 work sessions on it already. So I don't know what you want me to talk about, but I'll talk about whatever you say.
That's a great point, Janet. I know there's no further analysis, but are there any questions or comments for Janet Any clarification needed from committee at all? No? Any discussion at all, further discussion from the committee? Representative Wood.
Sorry, I'm Mr. Chair, I'm having a little bit of problem for some reason today with my internet. I wondered if we could bring Aaron McKean in from the attendees.
Is there a specific question, Representative Wood, you wanted to ask?
Yes, I thought I'd wait while he went through the netherworld.
Well, I need to understand why you want to bring him in first before I let him into the work session. Sorry.
Sorry. Yeah, I wanted to have a better understanding of the whole issue about foreign companies, and that we have a lot of companies, corporations in Maine that many of us don't even think of as a foreign company. For instance, I think a lot of people know that Irving is Canadian, but I think a lot of people don't realize that TD Bank is also a Canadian company. So I just wanted to hear from Mr. McKean about how would companies like those play into this whole notion of they would be banned from giving money. I know I've been involved in a lot of statewide referendums in Maine where particularly TD Bank has been a contributor to the referendum campaign. So would this disallow that?
Okay, fair enough. We will bring Mr. McKean in. Let's give him time to go through the portal, get acclimated to the time travel. Welcome, Mr. McKean. For the record, if you could state your name, where you're from, and who you represent, if anybody, please.
Sure. Good morning. Thank you for having me. My name is Aaron McKean, and I'm with the Campaign Legal Center. We're in Washington, D.C. And just so you know, we did submit testimony on this bill in support of it at the initial hearing.
Representative Wood, did you want to ask your question? Did you hear the question from Representative Wood, or would you like her to repeat that?
It would be great if you could repeat the question.
Sure. My question is about foreign corporations, foreign companies, and the fact that in Maine, we have a lot of companies here that we don't think of as being foreign owned. The two examples I gave were Irving Oil and TD Bank, which, as far as I know, are both Canadian companies. So if this went through as is, would those companies be banned from contributing? Because I've been involved in referendum campaigns where I know TD Bank has been a contributor. How would that play out?
Yeah, thanks for that. So as the bill is written right now, my understanding of it is that, basically those domestic subsidiaries, right, of foreign corporations would be prohibited from making those contributions. This is actually an issue both here, in Maine as well as at the federal level and a number of other states. And it does come up. I'm sure it's a bit more intense in Maine because of your border. And it does come up in other places as well, especially with corporations that we don't necessarily think of as foreign, right? 7-Eleven, right, is owned by, like a Japanese corporation, or Uber, right, is a corporation that has majority ownership or has significant ownership from, the Saudi Arabia oil. I guess it's their oil corporation. And so that does come up in other places. And this is, we see kind of the provisions here in the bill as written as kind of trying to plug that gap because, foreign corporate money often can come in kind of through these corporations, even though they're domestic. And so, I'm sorry?
No, go ahead. Go ahead if you're not finished.
Oh, I was just, yeah, I was just going to add, there are different levels, right, at which you could think of, foreign corporations and how much you want to kind of ban their, participation in, local ballot initiatives. And, what we see my understanding in Maine law is that there's really no, there's really no barrier at this point. Whereas, you could think of it as like steps up, right? If we think of the federal law that provides, a comprehensive definition, but it still has loopholes that allow for foreign influence corporations to participate. And then, you can also look to other states that also have, these bans, and they have kind of different details among them that we could look at in terms of how do you want to kind of set, what that ban would be.
Okay, thank you.
Mm-hmm. So, Mr. McKean, clearly your group is in favor of prohibiting foreign corporations, and I completely understand that. If we were to amend the bill to just include foreign individuals on ballot question initiatives, obviously we're not talking about candidate contributions. That's already separate. We're specifically talking about ballot issues. Mm-hmm. If we were to amend the bill to just specifically prohibit foreign individuals from contributing to ballot question initiatives, would that still be something that your organization could support as a stepping stone, or would you really want to see corporations only included in this?
So I think the way to think about it, right, is what are the loopholes that you're going to allow to continue as you scale down from what's currently in LD 479. What are the organizations or the corporations that you do want to be able to participate? And I can understand thinking about Maine, just like, so I'm from Wisconsin, and right, we have Canadian companies there as well. And thinking through that, that certainly is a part of the fabric, in the marketplace. But we would, the issue that we see here is with corporations in particular, we can get a little bit more granular, in terms of making sure that, I guess who's making those contributions is actually part of the kind of the political electorate. Leaving out corporations entirely, I think would be problematic. At least, I think it would make sense to sort of set the baseline at the federal level, and start from there, so that, at least there would be a comprehensive definition, and corporations would at least have some, they would want to have some sort of connection to Maine in order to be interested in, these kind of contributions. But I think it does leave significant loopholes open, for significant foreign meddling.
Okay, thank you, Mr. McKean. Representative Wood, did you have a follow-up?
No, sorry.
Okay. Okay, any other questions for Mr. McKean while we have him here? All right, seeing none, thank you, Mr. McKean, for being available this afternoon.
Thank you. I'll continue to be available if there's any, issues that you want to work through in terms of thinking about kind of the corporations that you're considering for this.
Thank you. Any other questions, comments, concerns from the committee? We've seen the analysis a number of times. I don't know if everybody's had a chance to consider their thoughts. I'm also seeing no senators and not a quorum, so we cannot take a vote even if we wanted to at this point. Okay. So I guess I'll just weigh in then. I'll wax and wane philosophical for a little bit. I appreciate the the need to restrict foreign investment in domestic politics across the board. I very much appreciate that. My concern is that we're casting a very broad net, and some of the companies that Representative Wood had mentioned, like TD Bank North, Irving, companies that have a long vested interest in Maine and contribute a lot to our economy and our culture, may unintentionally be restricted from participating in the ballot questions, ballot initiatives that affect them and affect all of us. So I'm hesitant to support the bill as it's written now. I think I would be probably more comfortable having some kind of work group or some collective group get together, work on the issues, and really try and make sure that we achieve the ultimate goal of preventing undue influence, for sure, in a referendum situation, but not restrict companies that we want to do business and want to be part of our fabric and culture from participating in those actions. So I'm going to have a hard time supporting the bill as it's written now. And I'll just leave it at that. We do not have enough of a quorum or a senator present if we were going to make a motion or move anyway. So I don't know if anybody else wants to add their 2 cents to it. Well, I look for a senator if someone is going to make a motion. Representative McCrate.
Thank you, Mr. Chair. Are you suggesting that we might turn this into some sort of study? Is that a suggestion?
I don't have a formal proposal, and I haven't been in discussions with any of the stakeholders to say that needs to happen. For me to support it, I would like to see something like that. I'd like to see the details worked out a little bit more. I understand what the intent is of the sponsor, and I don't necessarily disagree with that. I think it's the Hippocratic process, right? First, do no harm. And I'm afraid that this bill as written and as presented now is a little too far reaching for me. So I'd rather see us put some time. It's an important issue. I don't know the sense of urgency with this. I don't feel like there's a sense of urgency. So I'd rather see us put the time into putting something together that is a little bit tighter, I guess, for lack of a better word, if that helps. So we have Senator Lucchini present now. If someone were to want to make a motion on this. Okay, Representative Kinney.
All right, if no one else wants to do it, I'll make a motion on LD 479 not to pass.
All right. Motion ought not to pass by Representative Kinney, seconded by Representative Wood. Any further discussion? Senator Lucchini, you had your hand up, or was that for motion?
Sorry, yeah, I was gonna jump in for motion, but that's fine. No, I'll support the motion. I think, and apologies for not being here all morning, but I think as written, it would preclude a lot of pretty much US businesses from being able to engage in the initiative process just because they took, like in the case of a lot of technology companies, they took early seed capital from some sovereign wealth fund or something. And frankly, I don't want to be the only state that does that, because it would, I don't think, be a good incentive for any of them to come here and do business with us. So I think the law in Seattle that's similar to this was pretty much geared towards Amazon and I think probably companies like Uber. So I don't see us having that same issue.
Thank you, Senator Lucchini. Representative Kinney.
Thank you, Mr. Chair. Yeah, we passed LD 174 in committee. It hasn't made it to the floor yet. Probably we'll see that next week. And I guess I'd like to see where that one goes before trying to make additional changes and then have to deal with errors and things like that. Janet does a great job with all of that stuff, but I think we've already got a long errors bill that I'd hate to try to mess with it again. So hence my motion.
Thank you, Representative Kinney. Senator Farron.
Yeah, again, apologies for being late to the game. Senator Lucchini bailed us out as usual, so appreciate that. But exactly what Representative Kinney just said. We passed LD 194. I think that that's a step towards the direction. We'll see what the impact that has on the process, and that this is a bridge too far. So I'll be supporting the motion.
Okay. Thank you, Senator Farren. Any other questions, comment, debate? Okay, seeing none, the motion on the floor is ought not to pass. Karen, when you are ready, let's call the roll, please.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika. Representative Supika, absent. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. Ten in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So the motion ought not to pass is successful by unanimous of all those present. The 3 absentees will have until noon on Monday to cast their ballot, their vote. All right. Can we move on to LD 1363, please, Janet, when you are ready?
Is it possible to request a 5-minute break?
Sure.
Use the facility.
Absolutely. Yes, indeed, indeed. Why don't we take a 5-minute recess for people to bio break and reload your coffee cups?
We're still being recorded, so it's still embarrassing, but that was highly embarrassing. That's all I have to say.
You were just saying what everybody was thinking, Janet, that's all. It takes courage to express that. Apparently people had a lot more residual coffee than I thought. It's taken a little bit longer. All right, we'll give everybody just a couple more minutes to get in and turn their cameras on. We don't need a quorum to restart, but I know everybody's going to want to hear Janet's full analysis in order to help make their determination on the best way to vote this bill.
I've got to slip out of here in a few. We've got appropriations at 1 o'clock going over the new budget stuff, and I want to get something in my belly.
Do you want to vote now, Representative Corey? I'm kidding. I'm kidding.
Let me try to figure out what you're going to do.
All right, Janet. Well, let's see. In deference to Representative Corey and other people's schedules too, why don't you go ahead and start? It'll be on YouTube too as well. So looks like people
Did
are
you
starting.
say LD 1363?
Yes, please. Did I misquote that?
No, I just don't know what you want me to start on because
Okay.
we already had a work session on it. So there is bill analysis. I did send you a follow-up memo just to go over some of the things, the notes that I took, but I don't know what you want to do because not everything's on that memo. It's just something for which there was worth taking a note. Like there are provisions in the bill that nobody really said anything about, so I didn't write anything down.
Yeah, if you want to maybe hit us with your notes and give us an idea, that'd be a good starting point for us, I think, for sure. Please.
So LD 1363 is the Secretary of State's bill, an act to amend the laws governing elections. It has many, many different provisions touching different areas of the law. And because of that, there were a bunch of potential conflicts with different bills you were considering at the time or that are still on the slate even for today. And then there were some proposed amendments. So I did just want to point out that, and I numbered this in the left-hand column, both by the number that it has in the bill analysis, excuse me, and the number in the section of the bill itself, depending on which one you wanted to look at. So there was a proposed amendment for the Secretary of State's office regarding certification by the governor of the results of a presidential election subject to ranked choice voting. So this would be the general election. And the committee didn't decide whether to incorporate that proposed amendment. We just talked about it, but there was no sort of like sense of how the committee felt about it. And I just want to point out that during the hearings earlier this week on the National Popular Vote Compact, the Secretary of State indicated that for those bills, if you move forward on those, she was proposing you add back in ranked choice voting because both of those bills as drafted get rid of it for the general election for the president. And then if you do so, then this proposed amendment she has in 1363 about the governor certifying the results of the presidential general election and basing it on the final tabulation, the final round of tabulation, that it would be important to have this amendment as well enacted, although she does still hope that you'll consider putting it in 1363. Then item 4, which is about the provision about how a party that's qualified can retain its qualified status. You did take the proposal from LD 1363 with some technical cleanup of it, and you decided, as a majority of this committee, decided to put it in 1061. So it is there already. As far as the part of the bill that talks about when the party sends a notice to the Secretary of State talking about the enrollment qualifications to vote in a primary, that potentially conflicts with some of the open primary bills, which have not yet been voted. And the Secretary of State did indicate at your last work session that she would be amenable to removing the provision of the bill. She wasn't intending to make a substantive change to the law here, just clarification. And if you wanted to just proceed with up or down vote on open primaries and take care of it there, that was something she was willing to consider. I mean, obviously it's up to you. She didn't pretend otherwise, so don't use my language against her. As far as the provision in Section 8 of the bill that talks about the determination of whether you need a presidential primary election, and if you do, all of the dates surrounding it. I think this was a confusion caused by me. When I was looking at it, I got really nervous in the work session that the interaction between this bill and then LD 231, which is one of the open or semi-open primary bills that would apply to presidential elections. I was just a little bit worried about the dates and whether there would be a problem. But when I re-examined it, I don't think there's actually a conflict substantively, other than the fact that if you enact LD 1363 and you keep this provision in, you're amending the date by which something has to happen. And that something is, again, the party telling the Secretary of State who is qualified to vote in the presidential primary. If you enact LD 231, the party doesn't have the opportunity to make that decision because unenrolled voters will be able to choose to vote in that primary. So it will create a conflict if both are enacted, but I don't think it will be confusing to anyone what the law is, because the newly enacted provision from 231, if that is enacted, will say that the party doesn't get to choose. So it would be something you'd have to clamp with an errors bill, but I don't think there's a date issue. And I was worried about that before, and I just wanted to clarify that's not really an issue. As far as drop boxes, there were two bills that had conflicting provisions, but both of those were voted out not to pass in this committee. So that's not an issue anymore. There were a bunch of concerns and drafting issues surrounding the drop boxes. So as far as the clerk's concerns, which involved the staffing that would be required to monitor and retrieve absentee ballots if there are multiple drop boxes, and all of this stuff, the issues surrounding multiple drop boxes, you didn't discuss what you would do and whether to do anything about that. And then I had some questions about whether, as far as drafting questions about whether the intent was to go with what the bill actually says. I'm not sure it was intended to say, but what it technically says is that anyone can return an absentee ballot in a drop box. Under current law, if you use the assistance of an aide to mark your ballot, you can't use a drop box to return your ballot. And also, if your ballot is delivered to you or returned by a third person, which means somebody who's not your immediate family member, then you're not allowed to use the drop box. And it was just a question for you about which approach do you want to go with, and making sure that the bill and current law match. So either amend the bill to match current law or amend current law to match the bill, whichever one. And then also, I had some questions about maybe streamlining the language, and I actually explained those in the bill analysis for LD 1276, which had a very similar amendment, but we can go over that if you want to. I just wanted to point that out. As far as the provision of the bill that would provide in LD 1363 that if you are an absentee voter and you want the ability or the opportunity to cure any defects that might be found on the return envelope, the way 1363 is drafted, it says if you wish to have that opportunity, you need to supply a telephone number, email address, or both. LD 148, which is the ongoing absentee voting bill, that also had a provision that just across the board said, whenever you apply for an absentee ballot, whether it's for a regular absentee ballot or ongoing absentee voter status, whenever you apply, that you be given the opportunity to provide your telephone number or email address. It doesn't tie that to the ability then to later ask that your ballot defects be cured or the return envelope defects be cured. So it's just more of a general provision. So that's something you might want to reconcile, either take it out of LD 148 and just go with the approach in 1363, or allow LD 148 to stand on its own and then just copy that provision into 1363 so that they're the same, so that they won't be a conflict if they're both enacted. And that would mean that that provision would just say, ask somebody applying for absentee ballot to provide their telephone number or email address. And you could then amend the provision of 1363 that talks about the cure process and say that they only have to call you or email you if you actually gave them the telephone number or the email address. So just sort of, you can tie up those loose ends, but I just wanted you to remember that the majority report for LD 148 does have that similar provision. As far as sections 15 and 16 of the bill, which are intended to clarify exactly what the contents are of a telephone application for an absentee ballot or an absentee ballot application over the internet. There were just some technical issues about making sure that the cross references that are used don't suggest that somebody submitting a telephone or electronic application would have the opportunity to designate a third person. And you all sounded like you agreed with clearing that up if the bill moves forward. So I just wanted to remind you of that. Section 17 of this bill, which is item 9 in the bill analysis, specifies that a clerk is not required to issue an absentee ballot until they actually have the official ballots, because you can request the ballot up to 3 months in advance. You may not have the ballots until 30 days in advance. So that was a cleanup. You did put that in the majority amendment LD 148. But if you keep it in 1363, it will create a conflict with 148, because 148 does some other things too, including by specifying when an ongoing absentee voter gets their ballot. And also you added the substance of LD 451 and 456, which was to say that if it's a general election, you can't designate a party on the return envelope. So in that sense, it would create a conflict if you keep section 17 in this bill. But then again, if LD 148 doesn't pass, then you don't have the clarification that 1363 is trying to do. So it's a trade-off question for you. Item 9 in the bill analysis discusses the provision of this bill that would specify that a candidate may only be issued their own ballot. They can't have a family member's ballot and then deliver it to the family member, for example. Where that is placed is right in the restrictions about the reasons for requesting an absentee ballot after the 3rd business day. We've talked about that many times here. Because of that, it involves moving a punctuation around, so it would create a conflict with LD 1575 if you keep that provision about no excuse absentee voting. If you amend that in any way, you might create some kind of a conflict, because 1363 is premised upon the idea that no excuse absentee voting won't be changed. And then there is another provision in 1575, which we're going to talk about next, or at least is on the schedule, that says that the Secretary of State provides some uniform language for the municipalities to use in explaining to voters about what excuses are required after the deadline for no excuse absentee voting. And that's written sort of as freestanding language. So I think we can work on amending 1363, or not amending it, but maybe amending 1575 in a way that if you just go with that language, we can make sure it doesn't conflict with 1363. So I just wanted you to know that they're kind of technical conflicts, but we can work those out. Section 21 of this bill talks about in-person absentee voting, and it creates the requirement that the clerk verify the identity of the person who comes into in-person absentee vote by getting their birth year, their residence address. That is an amendment to the same section of the bill that's being amended in, the same section of current law that's being amended in 1575 differently to require the municipal offices to be open for 4 hours on Friday for in-person absentee voting. So again, that's a potential conflict depending on what you do with each of these bills. The conflict that was in LD 208, however, you got rid of because you voted 208 not to pass. So that's something. As far as the curing process for defects found on return envelopes, there was a conflict with 148, but you took it out of that bill. 1575, similar to what LD 148 did, says that the Secretary of State should adopt a process in rules about how you cure defects. That's different substantively than this bill, which adopts the process in statute. So that's just something to remember. If you want it in rulemaking, that's the 1575 approach. If you prefer in statute, that's the approach in this bill. There had been a concern from the Clerks Association, and if you were just looking at the bill analysis, you might be worried about it, but it's not actually a concern because the Clerks Association was concerned that the outcome of some of the cure process is that they might accept a ballot but then challenge it. And the Clerks Association worried about the increased number of post-election hearings they would have to evaluate the challenge. And that's just to see, because ordinarily challenges are about whether somebody is qualified to vote in that area. So after the election, you would have a hearing to then decide whether the person should stay on the voter registration list for that area. Secretary of State's office explained that the way they drafted it and their intent is that the challenge is only for the purposes of if there's enough challenge ballots that the election has to go to the Supreme Judicial Court to make a final determination, then at that point, the court would look at the return envelopes and decide, is that a defect or not? Should that ballot be counted or not? And that's the sort of resolution that would happen after the election. But they did not intend the clerks to be holding their own sort of resolutions after the election about the defects on the potential defects on the return envelope. In addition, there were some questions because the way the bill is drafted, it doesn't look like it follows current law, where if you're looking at the return envelope, you're supposed to be comparing the signature of the voter on that return envelope to the signature on the absentee ballot application. But as we talked about earlier, sometimes you apply for an absentee ballot by telephone or over the internet, so you didn't sign anything. And current law says that when they're comparing signatures, you only compare signatures if there is one to compare. And that wasn't as clear in this draft. Secretary of State's office said that they intended that current law to still be true. So if you use the assistance of an aide, or if you applied over the internet or by telephone, there isn't a signature to compare, that's fine. They're not going to automatically find it as a defect. And then also, there were just some other technical little questions I had about the amendment that they clarified, because there was one way of reading it that said that if there's a mismatched signature, that's the one area where a signature not matching, that's the one area where the bill says, okay, the clerks should try and get that cured, but they shouldn't make the final determination that the signatures don't match. They would accept and then challenge the ballot. And then it's just that in one provision of the bill, it looked like they would actually reject it as opposed to accepting and challenging it. And so the Secretary of State's office clarified they did mean accepting and challenging. So that issue was resolved, at least as far as the intent of the bill, and that could easily be clarified. And then I just wanted to point out that we had talked about maybe having me, if you want to go forward with this, work with the Secretary of State's office to maybe streamline this provision a little. It's written sort of as instructions for clerks, and you can write statutes in a more parsimonious manner. And so you had talked about maybe that would be okay to do. Obviously, I'd work with them to make sure I didn't change the substance if it was substance that you wanted to keep in the bill. As far as the reasons to reject an absentee ballot in section 27 of the bill, we talked about at the last work session that there was an inadvertent drafting error in the bill. So under current law, an absentee ballot can be rejected if the voter's not registered to vote or if they're not enrolled when necessary. So that would be like if they tried to submit an absentee ballot in a Republican primary and they were in the Green Party under current law, that wouldn't be okay. So it was an error to omit that. So the Secretary of State's office said, please put that back in if you go forward with section 27 of the bill. Then as far as automatic voter registration, there had been an issue I raised because it looked like Section 3 of the bill was trying to incorporate some of the changes this committee proposed in a bill passed out of the 129th, but that didn't finally get voted on. And there was just one little piece different. So the Bureau of Motor Vehicles under current law has to scan all of the information that would be used for automatic voter registration under LD 1363, and the version of that similar bill that was passed by this committee last time, or a majority of this committee last time, instead of scanning it, they would be recording it. And then also last time, the committee or the majority report also said you only record the information that is proof of voter eligibility. You don't need all the other stuff recorded in the pending voter registration record. And so it seemed like the sense of this committee was, yes, let's fix that. And the Secretary of State's office agreed to that at the last work session as a okay idea. Then also there was a proposed amendment for the Secretary of State about the implementation date of automatic voter registration. So that law, which was passed, doesn't take effect until January 1st, 2022. So if you were to look up the automatic voter registration statutes online right now, you would see them, all of them say not effective until January 1st, 2022. But as soon as that date comes around, automatic voter registration should be taking place at the Bureau of Motor Vehicles. The Secretary of State asked that you consider amending this bill to delay or allow for the possible delay of the implementation of automatic voter registration until June 1st. So the Secretary of State's office would implement it just as soon as possible. If they're ready on January 1st, they would do so. But if it takes longer, they would have until June 1st to implement it. And I talked to some other people in our office and we figured out a way we think we can make that happen by just amending one provision of the statute. So if you want to go forward with that amendment, I can work with Secretary of State's office to make sure I'm not misunderstanding their proposal, but I think we can do that. I bring that up because I was a little bit wary of like a weird effective date not being a date certain, but I don't actually think it's that weird now that I have reflected on it more. And then as far as the age of election clerks in Section 10 of the bill, one member of this committee did object to that provision. So I didn't want to not note that because I was writing down all of my notes from the meeting before. And then the last thing, although it wasn't in this bill, LD 1363, when you had your work session on LD 1013, which was about the absentee ballot tracking system, some people mentioned the possibility of rolling it into 1363. It was not clear to me that everybody wanted to do that, but I did just want to remind you because that bill is now on not to pass, so you might have forgotten about it. Because I would have if I hadn't written it down. I actually took that bill and just put a copy of it in this folder so I wouldn't forget.
Thank you very much, Janet, for the update and encapsulating our myriad of discussions on a beautiful chart. I love charts.
Thank goodness, or else I'd be in trouble.
I'm going to have a t-shirt made up that just says I heart charts. So any questions, concerns from the committee regarding Janet's follow-up memo? Chairman Lucchini. Chairman Lucchini, you're on mute, sir.
Thank you. Not used to being on mute. So I think we spent a lot of time on this one last time, and I know I said I would try to bring an amendment because it looked like it could be kind of a party line issue because some of the underlying stuff that is changing was party line initially, like ranked choice voting and AVR. So if would it help expedite it? I mean, I'm happy to go down through that chart, Janet, and put out an amendment, and then we can vote it as is for the sake of time, or because I know some of the stuff that this is affecting just from our conversations last time are one of those things that just end up party line at times. So
I think that's fine. It might be better to just not read through the bill analysis, but just look at the items on the bill analysis because not everything's in that chart because not everything was discussed really. It depends, whatever makes you happy.
Well, I guess the analysis would work better then.
It's up to you. Yeah. Sorry.
Okay. All right, let's do the analysis then.
So the first part is about the ranked choice voting definition.
Yeah, I think we're good to keep that in.
Okay.
Yep. And then 2, I think, was also good as written. And then because that is required by the tabulator software. And then 3, there was a proposed amendment.
So it doesn't actually amend section 12 of the bill. I just stuck it in here because it's about ranked choice voting. So there is the item 3 on the bill analysis is about the tabulation for presidential primaries. Do you want that in as well?
I think the conforming amendment, is that what you're talking about under 3?
Just this part here.
Yeah, no, yeah, that's good. Yep, sorry. And then as well, I guess that proposed amendment from Secretary of State. And then B, I think we just take out completely, like 4, part 5, take out completely. As those were dealt with in a different bill. I think part 6, the only thing we would keep is that first bullet point and then strike the rest of it, as that might conflict with. Or sorry, strike the second bullet point.
Okay.
I guess in terms of 6, we can do the language that the Secretary of State offered for drop boxes.
So the Secretary of State's language is in the bill. I'm not sure what.
Okay, we'll keep it in then, I guess. Sorry.
How about, there was the question about multiple drop boxes by the Clerks Association.
Yeah, I think that the language from the Secretary of State keeps the multiple drop boxes,
Sorry.
right?
Didn't
Sorry.
understand that.
Yeah, no,
and
my
then
fault.
as far as the conflict with current law 754A, which says that it only allows certain people to return ballots by drop box, but the people it leaves out are anyone who has assistance in reading or marking their absentee ballot, and then anyone whose ballot was delivered by a third party. So do you want to amend current law, that 754A, to then allow everybody to use a drop box, or do you want to amend the bill 1363 to say only the people that 754A allows can use a drop box, if that makes sense?
Yeah, I think we want to keep it with current law, and if you want to work with Julie on the best way to write that on, because I think the Department of Justice kind of tells us, the DOJ tells us how to do that, and I'm fine to say that she may write rules if needed on that.
Okay, that was different than the accessibility guidelines. Sorry, but as long as we're okay.
Okay.
Okay, and are you okay with the streamlining? Potentially, it may not work. Okay.
I think so, yeah, whenever we can do that, it's good.
So for the next part, this is the one that's in LD 148 as well.
Yeah, I think this one, we may want to keep this one as is, and then if we have to change one on the floor, we can change it on the floor. Because it may be a conflict. That way we don't go into reconsidering and everything. if
Okay,
that
then.
works for people.
Yep, so this is section 14 of the bill. The way it's currently written is it says if you wish to have the opportunity to cure your defect, then you provide the telephone number and email address. I will point out as a, it might be pointed out later, but it doesn't actually require that in the cure process that you have provided your telephone number, email address. So that just may be something to clarify. If the bill says if you want an opportunity to cure, you need to give us your telephone number or email address, but then when it gets to the cure provision, it just says clerk, you need to call or email. It doesn't say only if you were given that information. I know that that may seem obvious, but it may be worth clarifying whether they're bound to somehow find the phone number or email, or if they only have to pursue those efforts if they were given it, if that is making any sense.
I hear you. Yeah. I'm going to bring in Julie on a couple of these, just on the technical stuff. So Deputy Flynn, if you can hear us, that would be, oh, I think we've got you in the meeting.
Yes, hi.
Sorry, so Deputy Flynn, would matching it with 148 clarify your issue, or do you like the language that you offered better?
I think we do need to clarify in the cure part of the process that the clerk can only cure it if the voter has provided a telephone number or an email.
Okay.
They use that to, those are the ways that they attempt to cure it. They shouldn't have to go out and search for something else. That's the requirement for them to use what they've been provided by the voter.
Okay. Yeah, then, and so Jana, would that be cleaner to do in like section 10 than section 8, or?
Right, so then my suggestion to you, if you want to avoid a potential conflict, is to just copy the telephone and email provision from LD 148's majority amendment, put that here instead. All that requires is that you be asked, and then clarify in the cure process what Deputy Secretary just said.
Okay, yeah, I think that's makes the most sense, and it's like a juggling act with all of these inherent conflicts between the number of bills that we have.
Okay, that would eliminate then the FOA review, because LD 148 doesn't have a confidentiality provision, so that's the only other thing I wanted to throw out there.
Yeah, I think we do want to make sure that that's confidential.
Okay. So I'll just write that in a separate subsection maybe so that it won't conflict.
Okay.
All right. So the next part here is about the clarifying exactly what the contents are of a telephone or an electronic absentee ballot application. That was something that I got the sense from the last work session that the Deputy Secretary would be willing to work with me on if you wanted to authorize us to make sure it has all of the right information, but none of the wrong and applicable information.
Yep, I think that would be great.
The next part is in LD 148, I believe. Yep. So this is the part of the bill that talks about even though you apply for an absentee ballot maybe 60 days before the election, you can't actually be immediately issued it until the clerk has the ballots for the election. This was included in LD 148. This may be a conflict you're willing to live with and just keep it in here as well.
Yeah, I
Because
think
LD
that,
148 includes it, but also other things.
yeah, I think it's probably one that we want to keep just to make sure that clerks aren't on the hook for giving ballots when somebody requests one so far in advance, and then the people don't realize that the clerks don't even have the ballots until about 30 days before.
Okay. And then as far as the next piece is the candidates only getting their own ballot, since it's against the law for them to get anybody else's. It's a Class C crime. It's going to make a technical conflict with
Just a punctuation thing, or sorry.
with 1575, there'll be a technical conflict, but it really depends on what you do in 1575, so we can probably address it there. If you
Okay.
want. The next part is again a potential conflict with 1575. This is the part that says if you're voting in person, absentee ballot with the clerk, you still have to provide some information to confirm your identity. That's 1363. 1575 also says that the office has to be open for 4 hours on Friday. So that's both in the same section, but it does different things.
I mean, I guess if we haven't moved anything on, if we just leave ours as is, and then I don't think we're going to keep that provision in 1575. So does that make sense?
Yeah, and if you do keep it in 1575, we can move it to try and avoid the conflict if you need.
Okay. Yeah, I don't think, I mean, I wouldn't support that provision in 1575.
Sorry, you don't know which bill's coming first.
No, I know there's so many bills, it's unreal.
And then the cure process. So the concern here, as I mentioned, Deputy Flynn explained, shouldn't be a concern because the intent is not what the clerks were worried it was. It's actually how I read the bill too. So I think she's right that it doesn't do that. We could probably make it clearer, but she's right that that's not an issue. So.
Okay.
And then there was a proposed amendment by the Secretary of State to add some further requirements in the provision of the bill about setting aside the ballots for 2 days. So the way the bill reads is the clerk set aside a ballot for 2 days if they think that there's a problem with a return envelope. During that time, they try and fix it. If they haven't been able to get it cured in that time, then they would reject it. But somebody could still come in later and cure it, in which case they'd sort of unreject it and back it up. And the idea that the proposal from the Deputy Secretary of State was to clarify that they need to update the central voter registration system with what subsequently happened.
Yep.
I think I'm summarizing that right.
Yeah, I think we just want to make sure that the CVR is very accurate to what happened after that change.
Okay.
Sorry, did I cut you off?
No, I don't mind. I don't like to listen to myself talk.
So I did cut you off.
There were some other sort of like streamlining kind of things. I think I understand the intent now is to have only worry about signatures being mismatched if you actually have a written application, so there's a signature to compare to, and if you didn't have the assistance of an aide who would have signed, and so your signature wouldn't match theirs. So that kind of stuff, I think if you're okay with that, we can work that out when we look at this language.
Yep. Yeah, I'm good. And then I think those type of drafting issues we can look at again too at language review.
The next part was whether you wanted to include the fix for the drafting error.
Just adding back that piece.
I don't know how there aren't like a million more drafting errors in a bill this long. So
It's a huge bill. But this is like adding back the thing, if you're not registered, then you can't vote pretty much, right?
Correct.
Yep.
Yeah. And then there's the alternative signatures. Petitions for citizens and issues and people's vetoes as required now by the Constitution.
Yep.
Assume that you want that in, yeah?
Yeah, yep, that matches that constitutional amendment last session.
The next part is automatic voter registration to basically make the changes to that law that this committee or a majority of this committee voted for in the 129th, which is clarifying you record instead of scan the documentation.
Yep.
The friendly amendment that wasn't objected to, it only being voter eligibility proof, et cetera, and so forth.
Yep. And then we can do that discretionary kind of date, or if we can figure out the wording on that period, as you had kind of worked with Julie and others on a way we can make that work.
Yeah, I talked to actually Peggy in our office, and she and I had an idea on that. So
great.
I was overcomplicating it as usual.
Okay.
And the next one is about the number of signatures. We didn't really discuss this much last time, so I don't know if you want this in.
I think that's good. Yeah, it gives people a little more breathing room.
And then the last piece is the age of the election clerks.
Yeah, I think that's good to keep in, and then also add in tracker thing, which your chart reminds me, to say the Secretary of State shall implement the an online tracker, and has the authority to determine the display, which fields to display, type of thing. If that makes sense.
Yep.
I can't wait to see, Senator Lucchini, how you put all of that in the form of a motion.
Yeah, sorry, I was supposed to try to get this done in advance. I know, because we knew we would end up kind of where we would be. So, but I got slammed with several other bills. So I guess, Mr. Chair, I can make a motion if there's no other discussion, and then, or we can discuss after, whichever.
I'll entertain a motion, certainly.
I'd make a motion of to pass as amended, with the amendment being the kind of decision points we just walked through with Janet.
Second.
All right. Okay, so motion ought to pass as amended by Senator Chairman Lucchini, seconded by Representative Riley. Discussion. I'm just going to say, oh, sorry, Representative McCrate.
I'm just going to say that was impressive.
That was all Janet's breakdown of that bill was amazing. Yeah. And Julie's help. I was on the phone with at least an hour with Julie trying to figure out what was going on in each of those. So.
Yeah, I was going to echo that, Representative McCrate. That was pretty impressive watching everybody work on that, ping that off. So I think we'll have a good piece of legislature coming out the back end of that for sure. Any other questions, comments? We have enough for a quorum. 1, 2, 3, 4, 5, 6, 7, 8. Yeah, we have enough and a senator. So Karen, motion is ought to pass as amended. When you are ready, please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika. Representative Supika, absent. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
No.
Representative Kinney, no. Representative Harrington.
No.
Representative Harrington, no. Representative Corey. Representative Corey, absent. Representative Dolph.
No.
Representative Dolph, no. Senator Farren.
No.
Senator Farren, no. Five in favor of the motion, 4 opposed to the motion, and 4 members absent, Mr. Chair.
Thank you, Karen. So the motion ought to pass as amended passes. The 4 absentees will have until Monday at noon to cast their votes.
Can I have the minority report, please?
Ought not to pass for me.
Ditto.
That's fine with me.
Everybody on the minority okay with the ought not to pass?
Yes.
Okay. All right, perfect. All right, since Janet reminded me of the minority report again, which I very much need and appreciate, that just leaves the last bill on our schedule, which is LD 1575.
It also leaves amendment review, just remember.
Yes, I know, we have a long list of those too. Those will go hopefully fast.
Sorry, I just didn't want to forget. 1 second, I'm almost there.
Take your time. It's worth the charts.
I think I might have another one, maybe. Oh, no, I do.
Hello. Do we know, is Jenna or anybody joining us?
So LD 1575 is an act to improve election laws. You can tell I was tired because I forgot to give Representative McCray credit, so her name should be up there. My apologies. So the bill makes the following changes to the election laws. First, it allows student IDs as proof of identity. For voter registration, identity is underlined purposefully because there was some confusion in the way that the testimony that we received interpreted this provision. So I just want to remind you, under current law, when an individual first registers to vote in the state, the individual must provide one of the following forms of documentation to prove their identity: a government issued photo ID, a government issued non-photo ID, for example, a birth certificate or a signed social security card, or they can provide an official document showing their name and address, for example, a utility bill, a bank statement, a paycheck, or a government check, or they can provide their driver's license or non-driver ID number, or the last 4 digits of their social security number, and that's verified through the Central Voter Registration System. So this bill would authorize a voter registration applicant the alternative to prove their identity with a student identification card that has a photograph if the card is issued by a public school, an approved private school, or an authorized institution of higher learning. The next part of the bill talks about listing the drop box locations and in-person absentee voting times in the notice of election. So just to remind you what that notice is, under current law, a municipal clerk has to post a notice of election in a conspicuous public place in each voting district at least 7 days immediately before election day and at each voting place on election day. The notice has many required components, including the day, date, and title of the election, identification of the voting district, the name and location of the voting place, the poll opening and closing times, and a list of everything that's going to be voted on in the election. In addition, under current law, if the clerk will be processing absentee ballots before election day, that information has to be on the notice of election. Or if the clerk will be processing ballots at designated times on election day, but before the polls close, then that information has to be posted either on the notice of election or with the notice of election, the way current law is written. So the bill amends the notice of election law to require the municipal clerk to include on that notice the location of any ballot drop boxes, and then would allow the clerk to include information on the times for in-person absentee voting on that notice. In a completely different section of the bill, section 8, the bill also provides that a municipal clerk is required to provide notice of the designated times that the absentee ballots will be processed before the polls close on election day, only if the municipal clerk does not intend to process absentee ballots before election day. So those are the two parts of the bill that affect the notice of election or the notice that's given around the same time. I did have a technical question about talking about ballot drop boxes. It might be good to try and use sort of consistency in the statute to discuss them and talk about secured drop boxes, or just make sure that the language used maybe in this bill and 1363 is the same, so we don't have multiple different ways of describing them. And then also this provision here, I'm not exactly sure if it's intended to do what it says, because it just seems a little bit odd, but maybe I'm just not understanding the purpose of it. So I did have a question about that. The next section of the bill, section 3, talks about access to the polling place by nonpartisan observers and others. So this affects the provision of law that talks about the size of polling places. So under current law, general rules for the size is that there's a guardrail enclosure 6 feet around the voting booths. That's kept in the bill. The bill also has some kind of general statements about room inside the polling place, which include that it has to be large enough to allow public observation. And also there's a provision in the bill that talks about allowing reasonable access to members of the media within the polling place. So that's sort of a general provision that's in there. In addition, there are some specific rules about each segment of the polling place, and each segment is where a different portion of the incoming voter list registration list is, or the incoming, well, the list they use to say who can vote. I can't think of the name of it right now, but each section, so if they divide it alphabetically within the polling place, each section has these requirements. So under current law, at least one poll watcher from each political party must be allowed in that section outside of the guardrail. In addition, additional party workers and others, that's the statutory phrase right now, are allowed if there's space, but the warden can prohibit their presence if there isn't enough space. Under the bill, outside of the guardrail, but in each of these segments of the polling place, you'd still have to have one poll watcher from each political party allowed at least, and at least one nonpartisan observer. Additional party workers or nonpartisan observers, no longer others, would be allowed if there's space. But again, the warden could prohibit those extra people if there isn't space, and they would interfere with the election process. There is also provision in current law about how complaints may be filed that maybe the polling place isn't large enough. So under current law, you can file a written complaint with the Secretary of State. The people who can file it are the chairs of the party's state committees. They have to file their written complaint at least 60 days before the election, and they would allege in their complaint inadequate space for party poll watchers. Under the bill, the written complaint is still filed with the Secretary of State. In addition, the party state committee chairs can still file it, or a representative of an organization that conducts nonpartisan election observation could file a complaint. The deadline for the complaint would be changed to within 14 days of publication of the location of the polling place, and they'd have to allege inadequate space for the party poll watchers or nonpartisan observers. There is a red asterisk here to point out that I don't know what is meant by the publication of the location of the polling place. That may be really obvious and I just didn't see it in the statute. But I wondered if that meant the date the notice of election is posted, because that's publicly posted and it says where the polling place is, or did that mean that the date under a different statute that the clerk has to notify the Secretary of State at least 60 days before the election of the location of the polling place under a different statute. But since that's a notification to the Secretary of State, I wasn't sure if that's what was meant, because it talks about publication of the location. So that may be something worth clarifying. And then the resolution of the complaint, just so that you know what has to happen within either 60 days of current law or 14 days of the election, if you go with the bill, is the Secretary of State has to provide for inspection of the polling place to examine the size. If they conclude it's too small, then the municipal officers have to be instructed to select a new polling place, and notice of that new place has to be advertised at least 3 times in either the daily or weekly local newspaper or both. There's also a provision in the bill to affect no excuse absentee voting and in-person absentee voting. So under current law, as you know, if you are the municipal clerk and you receive an absentee ballot application after the 3rd business day before the election, so after Thursday before the election, you can't issue the absentee ballot unless the voter signed the application and stated one of the 4 reasons for a late absentee ballot application. I'm not going to read them again because we talked about them many times. The bill would permit no excuse absentee voting on the Friday before the election, so it changes that deadline. It also requires municipalities with more than 500 registered voters to allow in-person absentee voting at the clerk's office for at least 4 hours on the Friday before the election. So because it's the Friday, that would be no excuse in-person absentee voting. We talked about a potential conflict with LD 1363, but we can work that out if we decide what you want to do with this bill. I'm going to stop now if you want me to answer Representative McCrate's question.
Sure, thank you, Janet. Representative McCrate.
I'm sorry to interrupt, Janet, but are we looking at, we're not looking at the amended version?
No, this is the analysis of the bill.
Okay, so we're going to get there because a lot of this isn't there anymore.
Oh, I'm sorry. I don't have to go through if you don't want me to.
No, that's okay. I just panicked for a minute because a lot of this is gone. Thank you.
Sorry. The bill also requires the Secretary of State to develop uniform language informing voters of the acceptable reasons for requesting an absentee ballot after the no excuse absentee voting deadline. And those instructions would have to appear on any signs at the municipal office and on any website, social media, or other media that the municipality uses to communicate election information. This, the reason I quoted it is this any signs at the municipal office language gave me pause. It may be helpful for you to clarify, do you mean every single sign that exists at the municipal office, only election related signs, or maybe only one sign per office? I don't really care what it means. I just want to make sure it says what you want it to say. As far as rules governing absentee ballot drop boxes, so this bill would require the Secretary of State to adopt rules for the design and security of absentee ballot drop boxes, as well as the chain of custody for ballots returned in drop boxes. And by mentioning rules, the question comes up, should they be routine, technical, or major substantive? And again, LD 1363, which it's not clear if it'll end up being a majority, but some of the members of the committee voted for, would again put this in statute as opposed to having it in rules. In addition, LD 1575 requires that the rules adopted by the Secretary of State authorize more than one drop box per municipality. That's all part of the rule provision. In addition, the bill provides for an opportunity to cure a defect on an absentee ballot return envelope. So unlike the bill you just considered, this bill would require the Secretary of State to adopt rules about that process for curing a defect on the return envelope. And the defects would be any signature discrepancy or missing signature. And again, because it's rules, it's are they routine, technical, or major substantive? And then again, LD 1363, as you know, took a different approach. Instead of rules, that would put it right in statute. And then there are some changes at the end of the bill to the laws governing the processing of absentee ballots. So in section 7 of the bill, there's a cross-reference that's changed, just kind of like buried in there in the middle. And the effect that that change has is that it would clarify that absentee ballots are not counted when those ballots are processed before the close of the polls on election day. In addition, in section 9 of the bill, there's some language added to section 760A to clarify that the procedures in that section of the law only apply when absentee ballots are processed at a central location on election day. I can link to this statute and show it to you. It's not clear to me whether that really works because some of the things that are required to happen under 760A happen before election day, but I'm not sure exactly of the intent of section 9, but that's what it says right now. The reason I underlined proof of identity when I talked about the first provision about a student ID is because there was some testimony that suggested that The address on the student ID would be important for showing the residency of that student. And as I read the bill only provides that a student photo ID could be used to prove identity. It doesn't talk about using that for proving residency. So I just wanted to remind you that it's a different statute governing residency. So under that current law, the Register of Voters has to consider or is allowed to consider several factors in determining the voter's residency for voting purposes. And those are listed here, and that law is not amended with the student ID provision. So it may be that you want it to be, in which case it's good I pointed it out so you can add it, but it may be that you don't want it to be, and I don't think that it is affecting residency proof, but we can talk about that more if you have questions. The sponsor does have a proposed amendment, which is separate because I had written this before I got that. And the Secretary of State had also proposed some amendments. I think that they're mostly included in the sponsor's proposed amendment. So I'm going to skip that for a second, if that's okay with you. And then there were some concerns by the Clerks Association, some individual clerks in the Maine Municipal Association about nonpartisan observers, concerned about how they select who can come. A lot of concern raised about referendum campaigns. If somebody comes in and they're not associated with a party, but they're associated with one side or other of the referendum, how can you only let one person in if maybe somebody on either side wants to observe, but then maybe there's not enough room? They were worried about the deadline for filing the complaints about the polling size because there's only those 14 days left in which to secure a new polling place if it's not large enough, and they didn't know if that was enough time to secure a place. They were worried, as you've heard in other bills this session, about moving the deadline for no excuse absentee voting and the administrative difficulties of changing that date. There were some concerns about requiring in-person absentee voting on Friday before the election, with a suggestion that that could be difficult maybe anyway, but certainly for towns that don't have their offices open that day. And then also there were concerns raised, as you heard, for LD 1363 about multiple locations for absentee ballot drop boxes. So now if the sponsor wants me to, I can show her amendment. So her amendment would keep the section of the bill that talks about using a student ID as proof of identity for voter registration. She would also keep the provision of the bill requiring the Secretary of State to develop uniform language explaining the acceptable reasons for voting by absentee ballot after the no excuse deadline. She would replace the section of the bill that talks about what's on the notice of election and instead require that the voting place report, which is filed 60 days before the election with the Secretary of State by the municipal clerk, she would add to that statute a requirement that the location of each ballot drop box be included in that report, as well as the times for in-person absentee voting. So it's just moving it from the notice of election to the voting place report. In addition, the provision of the bill, which is section 3, which is all about the polling place size and nonpartisan observer access, as well as maybe media or public access, and when you file a complaint, all of that, she would say strike that and replace it with adding a provision to that section of law, maybe a new subsection saying that the Secretary of State can adopt rules governing observers in the polling place. And then those rules could then address some of the issues about nonpartisan observers. Maybe if there's time, she can probably explain that better than I can, sort of the intent of that section. And then many provisions of the bill she is proposing to strike. So no longer changing the deadline for no excuse absentee voting, no longer requiring municipalities with more than 500 registered voters to be open for 4 hours on Friday for in-person absentee voting before the election, not talking about absentee ballots or the curing process for return envelopes in this bill, and instead moving with 1363, which you did keep it in that for the majority report. I think it's a majority, I'm not sure, it depends on all the votes. And then also not including sections 8 and 9 of the bill, which talk about the absentee ballot processing procedures. I believe that's the Secretary of State had testified that it might be better to look at that in a more comprehensive manner. And I think that's why that's included, but you can of course ask her.
All right, thank you, Janet. Representative McCrate.
Thank you, Mr. Chair. Thank you, Janet. I only panicked for a little while.
I'm sorry.
The amendment, we obviously got a lot of feedback. So I was, one of the things you learn as a social worker is you do better by listening than by talking. Might have been better to have some more of those opinions ahead of time, but because I didn't want to panic people, but Janet went through it very, very nicely. The only thing I wanted to comment on was the section about adopting rules around poll watchers. The intent of that was to take the nonpartisan issue out of the mix. It was really about behavior, because what I was hearing from clerks, they were concerned about adding another seat or more than one other seat, depending on the polling place. But what multiple people talked to me about was the observers who are already allowed to be there don't seem to understand what their role is or what the rules of the polling place are. So it's not intended to add a different category. It's to clarify how any poll watcher or poll observer should behave in terms of the rules. The warden's in charge. You stay in the designated area. You don't, you observe, you don't try to engage with voters, that kind of thing. And I spoke with Julie Flynn and yesterday about that would be something they could do through rulemaking. But it's not about, just want to clarify, it's not about nonpartisan observers. People were pretty clear that that could confuse things. And they are allowed now if there's space, and got good feedback about that, but they didn't want to have to add an extra chair. And they didn't want that reduced time for complaints for the reasons Janet just explained. I think that's really important. So it's quite different than the original bill in response to the feedback that we got and in response to other bills that we've already dealt with. Thanks.
Representative McCrate, we were working on this yesterday and we putting the list together for you. So I didn't have a chance to ask you because it was late and we'd gone back and forth, sorry. But can I then change it to poll or poll, whatever the word is, in poll watchers from current statute instead of poll observers, so it doesn't look like it's creating a new category?
Yes, please.
Thank you.
Okay, thank you, Representative McCrate. So Janet, are we comfortable with the actions we took on 1363 and what we were going to do in 1575, where the conflicts were?
Yes, if you're going to just keep the part of this bill that's in the section about excuse for absentee voting, it's that separate section that says that the Secretary of State develops uniform language. I might just make that its own subsection, exact same words, but then there's no problem with it potentially conflicting with 1363, which I can't remember what it did now, but it did something. Oh, it's about the candidate can only get their own ballot. So instead of any potential for conflicting, I wouldn't change the substance of it, except that I do want to know if you want it to still say any signs in the municipal office.
Representative McCrate.
Thank you, Mr. Chair. Thank you, Janet. Separate sections fine with me. This was something that every clerk I spoke to, and people who wrote didn't necessarily include the things they liked. They include the things they didn't like, but it was universal of clerks I talked to that they really liked the idea of uniform information. So that however you want to do that. And in terms of signs, it seems to me that should be on election related signs, not all signs.
Thank you, Representative McCrate. Are you good, Janet, with all the clarifications, or?
Yep.
Okay. Representative Dolph.
Thank you, Mr. Chair. I was just a little disappointed that student IDs weren't taken out, because students from all over can get an ID from school. We have a lot of exchange students that have IDs from school, people from other countries coming here to school who get these school IDs, but that's not saying that they are actually legal to vote. That's just, I wanted to make the comment. Thank you.
Yeah, Representative McCray.
Thank you, Mr. Chair. Thank you, Representative Doloff. Yeah, just to stress what Janet had said, we're talking about identity, not residence, not citizenship. Those things are checked otherwise. So it's just identity, not the other factors.
Okay, thank you, Representative McCray. Chairman Lucchini.
Thank you, Mr. Chair, and thank you, Representative McCray. I think I like the amendment. Obviously, there were a lot of issues with the original bill. Just one issue potentially that when I was talking with Deputy Flynn that we may want to consider is just being extra clear on, like in 759, when we talk about when ballots are counted, just to make sure that instead of how it says in current law that when the ballots are processed, they're counted, but to be clear that the ballots aren't counted till after the close of the polls on election day. That way we can, just to be crystal clear, that you can't count ballots before the close of the polls, just to give people comfort with that, which is the practice, but we just want to make sure that it's hard line in law that nobody can count ballots until after the polls close.
Representative McCray, you're okay with that? Okay. Any other questions, comments, discussion? Anybody want to make a motion? Chairman Lucchini.
Sure. Thank you, Mr. Chair. I guess I'll make a motion of ought to pass as amended with Representative McCrate's amendment plus that correction under 759-6.
Okay. Thank you, Chairman Lucchini. Is there a second?
Second.
Seconded by Representative Riley. And Janet, you're okay with the amendment? Any clarifications or anything you need on it?
Yeah, I do want to clarify a few things. So we're going to add back the part of section 8 that fixes the cross-reference, which is the part about you can't count the ballots before the polls close. Let me write that down because I can't think and talk at the same time. Okay, and then also changing observers in the polling place as far as the rulemaking to poll watchers in the polling place.
Mr. Chair, if I may.
Yes, please, Representative McCray.
Whatever the appropriate language that makes it clear, it's about guidance for behavior as opposed to adding new types.
Yeah.
Thank
and
you.
Then the one other thing was we were going to clarify it's only election related signs, not any sign in the municipality. Or that's what, not we, but that's what the representative had said she wanted to do.
Yeah.
And Chairman Lucchini, you're okay with that being part of your motion?
Sure. Well, I just had a question for Janet, I think on, I don't think it's adding back section 8 necessarily, what I was trying to do.
No, just the cross-reference change in section 8.
Okay. Gotcha.
And if you wanted me to, I could talk to the Secretary of State to see if that is the way you should fix it, or if you should actually change the language of subsection 6 itself, which is, so right now, 759 subsection 7 says, when you're processing the ballots before the polls close, use all of the procedures in subsections 1 to 6. And subsection 6 says, count the ballots as soon as you've done processing them. And so the bill gets rid of 6 and says, don't do that. Just go 1 through 5. So don't do the counting.
Okay.
So I think that cross-reference change fixes it, but it looks like Julie's saying no. So listen to her.
Deputy Flynn, would you like to weigh in, please? Oh, you're on mute, Deputy Flynn. Sorry.
Thank you for the opportunity. Subsection 6, unfortunately, is old language. Before, we used to process prior to the close of the polls. It said as soon as you're done processing, you may count the ballots. So that was a suggestion that we change that wording in subsection 6 to say you may not count until after the polls close on election day. That is absolutely what we have believed the law requires all along, but I think that section needs to definitely say that to be in compliance.
Thank you, Director Flynn. You get what you need, Janet? Okay. And Senator Lucchini, I assume your motion. Oh, sorry, Secretary Bellows. Yes, sorry.
I think this is minor technical, but I just wanted to draw your attention. I know you're keeping section 1, which we wholeheartedly support, but in Representative McCrate's original testimony and in our testimony as well, we had recommended a minor technical amendment to that language. And so I just wanted to flag that. Just to make sure that that's captured in your amendment as well, not the original language on that.
Yes, sorry, I didn't mention that. I skipped over your proposed amendments because I just went to the sponsors, but yeah, so the way it's written right now, if you look at section 1 of the bill, it adds to other official documents the student ID. It's my understanding that the proposal is to not keep it in that paragraph, but make it its own subsection.
That's right.
Okay. Anything else, Madam Secretary? No? Okay. Okay. Any other comments on amendments or technical language? Okay, seeing none. Senator Lucchini, I assume that your motion would cover all of these changes?
Yep.
Okay, and Representative Riley, you're okay with your second, holding your second? Okay. If there are no other discussion, then Karen, when you are ready, we can call the roll, please. The motion on the floor is ought to pass as amended.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren. I can come back to Senator Farren. He's absent right now. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
No.
Representative Kinney, no. Representative Harrington.
No.
Representative Harrington, no. Representative Corey. Representative Corey, absent. Representative Dollop.
No.
Representative Dollop, no. Eight in favor of the motion, 3 opposed to the motion, and 2 members absent, Mr. Chair.
Thank you, Karen. So the motion ought to pass as amended is successful. The 2 absentees will have until noon on Friday to record their votes.
And the minority report, Mr. Chair?
Noon on Monday, right?
Monday. Did I say Friday?
You said Friday, and would be
Friday on
ought
the
to pass.
Thank you.
Is everybody on the minority report okay with ought not to pass? Yes? Okay. Excellent. Thank you. Thank you. Thank you. All right. That concludes. Sorry?
Sorry. Thank you, Janet.
You're welcome.
So that concludes the list of bills we have scheduled for work session. So thank you, everybody, for your hard work today. I know we worked through lunch, and I appreciate you powering through with just a 5-minute bio break, but hopefully we'll have a chance to enjoy the rest of the afternoon, bright and sunny, after we do language reviews.
You scared me. So hopefully they're painless. The first one is an act to define the term unenrolled political action committee. It's LD 59. There was a minority straight ought to pass report, and this is just to show you that there's no fiscal note required on that.
Okay. Any questions?
Oh, sorry.
No, any questions? Everybody good with that?
The next one is, I'm afraid I'm going to sneeze, LD 202, which is the constitutional resolution about implementing ranked choice voting. This was a divided report. This is a majority ought to pass as amended report of 8 members of this committee. We did go through this language on March 26th, so it's mostly the same. There's only just been minor sort of revisor's office style technical changes, commas here. They use commas differently than me. I'm not very good with commas, and they always fix them. And so it basically, the original bill said that the majority vote winner as opposed to the plurality winner would win the election. And then you directed me to work with the sponsor and the Attorney General's office to make sure that it actually would implement ranked choice voting, which is what all of these changes do to the Constitution. Also changes the question to specify that when it goes to the polls, to specify that the vote is whether governor, state senator, and state representative be elected by majority of the votes cast for that office. And then there is a required fiscal note. I'm sure you're going to be shocked by this fiscal note. You've never seen such a thing before for a constitutional resolution, that if in fact it causes all of the questions together, cause the need for a second ballot page, there will be approximately $172,000 worth of additional ballot printing and delivering costs. I don't mean to say that like it's not important. It's just that it's not surprising.
All right, any questions from those on the majority report? No, seeing none, we can move on.
So LD 930 is an act to revise the reporting requirements for Maine Clean Election Act expenditures. That was a concept draft. It was a minority ought to pass as amended report. So the amendment takes the proposal from the sponsor during the work session, which is to require an itemized summary of expenditures that exceed $1,000. In the work session, it was just for Clean Election Act candidates. You directed me to add that to traditionally financed candidates. And because of that, we needed to change the title of the bill. So it's an act to revise reporting requirements for Maine Clean Election Act expenditures and increase campaign finance transparency. So then this first section adds that itemized expenditure for $1,000 or more to the provision of law governing traditionally financed candidates. And then section 1125 of Title 21A is your Clean Election Act requirements. And so that same language appears here to require that itemized expenditure of $1,000 or more for Clean Election Act candidates. And there is a fiscal note, which is a minor cost increase that can be absorbed.
Thank you, Janet. Any questions from those on the minority report? Okay, seeing none, we can move on to the next one.
The next one is 1061. So this is a divided report. So there's 7 members and it ought to pass as amended version that I'll show you in a second. There's 5 members who voted ought not to pass. And then Senator Hickman had his separate amendment, both of which are here. So the majority amendment no longer talks about seeking official party status. It's now about retaining qualified party status. So that required a change to the title of the bill. So it's now an act to protect minor political parties that seek to retain qualified party status. And this is the provision that comes out of LD 1363 that we talked about earlier. And that is to say, under current law, you have to have at least 10,000 voters voting and who are enrolled in your party voting in every general election, starting with the second and all subsequent general elections. This amendment instead says, starting with the second and subsequent general elections, you either have 10,000 voters enrolled in the party, not necessarily voting, or you've had your gubernatorial or presidential candidate receive at least 5% of the total votes cast for governor or president in the last general election. There is a fiscal note that's required for this majority report. Oh, so there's not. Ha, I didn't read my own handwriting. So it's no fiscal impact, so there won't be a fiscal note on that amendment. And then this is my.
Before you go, sorry, any questions from the majority on that amendment? Okay, seeing none, we can move on.
And then I don't know if Senator Hickman's still here.
He is.
Okay, good. I can't see him on my screen. So this is his minority report. So this is about more than just either seeking or retaining status. So there's a new title, it would just say an act to protect minor political parties. The first part of this, and it comes up several times in the amendment because there's scattered provisions of law you need to amend, which is about anyone being able to sign a primary petition. The next part is changing the requirement, eliminating the requirement that 10,000 voters be enrolled in the party in every second and subsequent general election to retain your qualified status. So that's eliminated in this amendment. Like the bill, this amendment reduces from 5,000 to 2,500 the number of new party members you have to enroll in the party to become qualified. But newly in this amendment, it changes the date upon which you have to get all of those members enrolled to March 15th of the even numbered year before the subsequent primary election, when you're going to have when you're going to be able to participate in the primary because you've now become a qualified party. This next part of the amendment is just another change of 5,000 to 2,500. This is the provision of law that talks about appealing a determination that you didn't make it to the 5,000 mark, so you need to change that to 2,500. And then the next portions of the amendment amend the laws that govern the signing of primary petitions, and they're all about making sure you don't have to be enrolled in the party to sign the primary petition. You still have to be in the election district though, and a registered voter. And then there's a shall to must. I never know when that's going to happen. Every time I think I understand the difference between shall and must in Maine statute, it changes again in my mind. So they fixed that, and I'm sure it's right because they understand that rule better than me. Again, there's no fiscal note needed for this minority report.
Thank you, Janet. Senator Hickman, any questions or concerns?
No, thank you, Mr. Chair. I think an individual shall and something else must. I think that's why they changed it, so that it's just people doing the shalls and other things being the musts. That's the way I read it, but yeah, it works. Thank you.
You are right. That is true. That part I get. It's sometimes the conditional statements though, when it's shall or must, I can't follow that one. And then this is a unanimous ought to pass report on eliminating the limit on the number of taste testing events, and just wanted you to see that there won't be a fiscal note required, so this can be reported out without needing to have an amendment.
Okay, any concerns or questions from anybody on that one? Okay, seeing none, thank you, Janet. Anything else that we need to cover today? Nothing from your end. Okay. Chairman Lucchini, any parting words of wisdom for the weekend?
I think we're good to go. Are we back Monday? Probably.
I believe we are back Monday. Yes, sir. Yeah.
Oh, I actually do want to say something. We did table that one bill. I don't have any instructions to do anything in the meantime. So if anybody wants to email me and ask me to put together a proposed amendment, since we're running out of time, just let me know.
Thank you, Janet. Representative Tuttle.
Mr. Chair, there'll be a cookout at Senator Lucchini's tomorrow afternoon at 1 p.m. So be
There
early.
we go.
No.
I'm not going to ask what you're bringing, Representative Tuttle, but I'll leave that to chance.
Well, being Irish, you know what it'll be.
Any other questions?
Sorry,
Any other
I'm half
questions or
Irish.
comments?
Mr. Chair, yeah, I did speak with Senator Maxman, and so she's going to be reaching out to Janet to work on an amendment to her bill.
Excellent. Thank you.
Between now and Monday. Thank you.
Thank you. Thank you. All right. If there's nothing left, thank you all for some great work today. I'm sorry to make you work through lunch, and hopefully we get to be rewarded on the back end with a nice long weekend. So enjoy. Thank you, and we'll see you all on Monday.